Hello? Hello?
TNA District Court for County of Washington, State of Michigan is now in session. All those have been reported on there. The Honorable Judge Judge Simpsons presides.
You may be seated. You don't have to sit down, but you may. You know, I got.
We gonna find her.
You gonna go find Tana? Because I got Hawthorne here. He don't know what he's doing. Lowe doesn't know. Lowe doesn't know the court rule.
I'm ready to go, Your Honor.
Yeah, I know. It's all set over here. That side looks a little bit discombobulated. I don't know.
Trying her best.
Well, Her Highness has arrived. All right. What'd you say?
Oh, the waiver.
Yes, I was waiting for the waiver and
I did not know.
We need some more training. No,
I know he heard it on both sides. I don't even, how do you not know it, Hawthorne?
Let's see how I do with it and then
Okay.
talk about not knowing it. I
All
don't know.
right, go ahead, Ms. Tanner.
Your Honor, at this time, the people of state of Michigan move to waive any potential conflict between Your Honor, Honorable Court, and the Public Defender's Office. We do not believe a waiver exists. However,
A conflict exists, you mean?
a conflict
Okay,
exists.
go ahead. I'm sorry.
A waiver does exist, a conflict, no. But if one were to arise, Your Honor, we would waive it.
All right, very good. Ms. Page, you know it, right?
I don't know, I screw it up all the time that I'm here.
You do, but go
I
ahead.
get through it though. Your Honor, Assistant Public Defender Natalie Faith, on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between our office and this honorable court, but if one were to arise, we would waive such a conflict.
Thank you, both. The court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of People versus Nicholas Pasanic.
Good afternoon, Your Honor. Marie Tannhouse, the prosecuting attorney on behalf of the people.
Assistant Public Defender Natalie Pay on behalf of Mr. Bosnack, who should be present via Zoom.
Well, I have two folks.
Sam's not Mr. Boston.
No.
See this on you.
Bosnick, is that how?
Yes, I'm here.
Yeah. Okay, I need a camera, please, sir.
It should be on. Yeah.
It may be covered.
It's off now. There it is.
How about now?
Yep, there he is. All the way from New Zealand.
Yes, Your Honor.
I see, I remember. I
Yes.
absolutely remember. Because I mispronounced his name and he's in New Zealand. That's how.
Yeah, he is here. And I have discussed this matter both with my client as well as with Ms. Zenda. And we were hoping, me and my client, to set this case for final settlement conference. I do not anticipate it moving forward to jury selection. I did speak with Ms. Zenda regarding her thoughts on that, and if the court were to somehow agree, if you would allow him to appear via Zoom for an August final settlement conference. I have discussed that with my client, and that is what he wishes to do. I do understand that the court typically has, of course, final settlement conferences in person.
Yes.
And I will just add for the record, if this does play a role, this is a 2003 case. And of course, as Your Honor is aware, he does reside in New Zealand.
Well, really what I should do is make him come here and then take us back with him to New Zealand. That's really what I should do. But
For the record, the people would leave it to the court's discretion.
All right, thank you. What I will do then is I will set jury final settlement conference for
August 8th, 2025 at 9 a.m.
okay, it is the 8th. August 8th, 2025, 9 a.m. Jury selection would be, if necessary, August 11th, 2025 at 8:30. What I'm going to do is I will mark the file in person, but then note that defendant I will permit to appear via Zoom, understand circumstances. If for whatever reason, so that the parties would know, if for whatever reason would need to go to trial, I would be setting the next dates, which would then be in October. Those would be in person, but the defendant's attendance would be mandatory at that point.
Absolutely, Your Honor.
Okay,
Thank you.
all right. Thank you.
Yeah.
Thank you, sir.
Thank you. And what are those dates for there?
August 8th,
Yep.
2025, that's at 9 a.m. That's the jury final settlement conference.
Yep.
I pair that up with the jury selection, understanding that it would not go because I'm allowing you to appear via Zoom at this point. Jury selection would be August 11th at 8.
The 11th at
Yes.
8:30.
Yes, sir. So you had the 8th and the 11th.
And the 11th at 8:30.
Yes, sir.
And that's AM US time.
Yes, yes, because I have no idea what time it is in New Zealand.
It's 5 a.m. right now.
Is it? Okay, 5 a.m. Are you still on our date? Because we're the what?
No,
30th?
I'm a day ahead. I'm on the 1st.
Yeah, that's what I thought. Okay.
Yep.
All righty, sir. You take care of yourself.
Great. Thank you so much. See you then.
Thank you, sir.
Court does call the case of the people versus Eric Buckner.
Afternoon, Your Honor, Marie Tannhouse, Assistant Prosecuting Attorney on behalf of the people. And Assistant Public Defender Natalie Pate on behalf of Mr. Buckner. Your Honor, I have spoken with Mr. Buckner several times in anticipation of this court date, and he was aware that he was to appear in person. My latest update from him was that he texted me at 1:01 stating that hold up, Your Honor, I apologize, that he is in the hospital. I asked for proof of his admission and he responded that he was talking to a nurse and he would send some, but I still have not received any. That is my explanation for his failure to appear. I do understand the situation, but for the record, would respectfully request an adjournment of this hearing.
In your response to the people.
Your Honor, I think the court knows more about the background of this case than I do, but my understanding is he is supposed to be here in person.
Yes.
I also have grave concerns about the safety of the victim. I have reason to believe that he has been stalking her, which would be no surprise given the background of this case. Given those concerns, Your Honor, I would ask for a warrant with a high surety bond.
What I will do in this case is I'll issue a bench warrant for the defendant's failure to appear. I'll set bond in this case in the amount of $15,000 cash surety is paid. If there is information that comes through, then the court won't have a problem necessarily setting it aside.
Absolutely, Your Honor.
All right, that warrant will issue immediately. Thank you. Court does call the case, People versus Douglas Lee. Uh-oh. Uh-oh. Hold on, slow down. Just slow down. Let's get it right.
Requesting permission to practice pursuant to Michigan Court Rule 8.120. Under the supervision of Assistant Prosecuting Attorney Maria Tan.
Permission to practice is great.
Her love for the people.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Lee, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Douglas Lee.
All right, thank you, sir.
Thank you, Your Honor. I have discussed this matter with my client, and at this time, he wishes to set the case for final settlement conference.
Jury final settlement conference, August 8th, 2025, 9 a.m. Jury selection if necessary, August 11, 2025, 8:30. Both of those proceedings are in person.
Yes, sir.
All right. Okay, thank you.
Thank you, Your Honor. Thank you, Mr. Lee.
Excuse me. What date was that? Is that August 8th?
Yes.
August 8th for jury final settlement conference, and then the August 11th would be jury selection if it's needed.
Yes, sir. Yes, sir. Thank you.
Thank you. Bond continued.
Thank you.
Court calls the case of the people versus Jaquil Lloyd.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Lloyd, who is present via Zoom. Sir, excuse me, can you please state your name for the court?
Yes, Jaquil Lloyd.
Thank you, Your Honor. As to the case itself, I have discussed this matter with my client.
Can you hear
And I
me?
respect.
Yes, we can hear you.
Hello?
Hello.
Hello, can you hear us?
Yes, now I can. Now I can, Your Honor. Now I can. Good afternoon,
All
Your
right.
Honor.
Good afternoon, sir. All right. You want jury final settlement conference?
Yes, please, Your Honor. And then if I may address an aspect as to bond briefly.
All right. Jury final settlement conference in this case will be set for August 8th, 2025 at 9 a.m. Jury selection if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person. Yes, as to bond.
Thank you, Your Honor. So Ms. Perrine covered this hearing for me last week when it was in front of, or not last week, 2 weeks ago when it was last in front of Your Honor, rather. And I believe the request was made for Mr. Lloyd to discontinue testing. To my understanding, it was denied at that time just to see that his levels, I believe, of marijuana were coming down. It is my understanding he has not used since his arraignment. The allegations in this case do not involve any sort of alcohol or drug use of any kind. And I would ask, given my client's expenses to pay, he has to pay each time he tests, and having to come, he does not reside in Washtenaw County. He hasn't had any bond violations to my understanding, and we are just asking that the testing discontinue.
Yes. Send us some level. Is there a response from the people?
If one moment. As long as he's clean or the levels of marijuana are coming down, then we would have no objection.
All right. So, Mr. Lloyd, you're gonna have to wait online. We're gonna try to get those from community corrections. Hopefully we'll have them momentarily and I'll call your case back up, okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court does call the case of people versus William Fridge.
Pretty clear on behalf of the Mr. Fridge was scheduled before the court for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance. Mr. Fridge did fail to appear for his last review hearing a couple weeks ago. Mr. Fridge was in contact with my office. I got him set up. He's working and got him set up with a payment plan that he can manage and has been reporting to me. Given that he's in compliance with that, probation is asking that the court indicate that he pay $125 per month beginning July 25th. He recently made a payment to the court, as noted, that he continue all of the terms as previously ordered, with the next review hearing date being set September 2nd, 2025 at 1 p.m.
And Ms. Flip, you're gonna communicate this if I order it to him?
I already did, John.
You already did,
Yes,
assuming that's what I was gonna do.
correct. I told him that was the
What?
recommendation. And he knows who makes the final call. Mr. Fridge does.
But nobody else does, it seems.
Oh, he knows.
No.
He knows.
All right, the court will, without objection, order that the defendant pay $125 per month beginning July 25th, 2025. I'll continue all terms as previously ordered. I'll set his next review hearing September 22nd, 2025 at 1 p.m.
Thank you, Your Honor.
While we await Community Corrections Court will stand in recess. Everybody can remain seated. Yeah, probably. Well, are we all set?
Yep, we are.
All right, we're back on the record in the case of the People versus Lloyd. Mr. Lloyd?
Yes. Yes, hello?
Yep, there you are. Okay, we received the results. Regrettably, you missed a test on June 25th.
I missed the test on June 25th.
Yes, sir.
I didn't know that.
Okay. Well, and your attorney, Ms. Pate, had indicated before we came back on the record, she was unaware of that also. It's unlikely that a violation, although I can't guarantee it, it's unlikely that a violation will be forthcoming, but you may want to contact Community Corrections to set up new testing.
Okay, today is my testing today. I'm actually on my way there now. Because today they called my name.
You're what?
I'm actually on my way to test right now. They called my name today, just now.
Did they? Okay. So go over and get the test, and then your attorney can maybe file a motion with the court, but I'm not going to do anything on this today.
Okay, and I have another question too, Your Honor. When would I be able to first face my accuser?
Do what?
Mr. Lloyd, we discussed that on the phone. Your next court date is August 8th.
Oh wait, you're right. I forgot. I'm sorry.
Get it?
Yep, I got it.
Okay.
Can I respond here?
Yes.
Your Honor, we were able to locate an expert that's specifically an expert on email forensics in Microsoft Outlook. And we did not obtain that person until last week. And I did not have a report in my hands until Thursday evening, which I didn't read until the morning before I sent it on to the prosecutor. So this is a new witness. And I told the prosecutor that I don't know if we're going to call him because it depends on whether Detective Parvis is familiar and is able to answer my questions on the various indicators of this email that we're going to get into. So, but if the court is not inclined,
But with
I won't.
reference-
But I just want to be able to have the witness here in court to observe, since he might be required at the next level if it goes there.
But your questioning Detective Parvis is going to relate to that new report.
It is, but I'm not going to ask him about the report. I'm just going to ask him about the concepts, Your Honor, and ask him what he saw in the artifacts that he looked at in the server log and other places. So I'm just asking the information. I'm not going to show him the report or ask him about the report.
Well, I guess I'm at a bit of a loss as to how you're going to do that without referencing the report.
It's just concepts and things that Detective Parvis.
Right, okay, I hear you, but are these new concepts?
Well, I haven't had.
And
Sorry.
are they new concepts that one would have to prepare to address them in a form? I mean, part of my concern is, counsel, is that if you're going to do that, then Detective Parvis's testimony could be misconstrued in terms of his response.
I'm not sure what you mean.
Well, let's say there's something in the report that says something. I can imagine a circumstance where you ask the question, Detective Parvis answers the question, based upon a certain understanding. That answer is then locked in. But then later on, there is this other really understanding that had that context been put on, there may have been a different response.
I don't intend to ask anything out of context. I intend to explain my questions, ask him about
Oh,
context,
but
what he saw and what he didn't see, that's all.
right, but it's going to be, I get what you're saying, but the context of some of your questioning is going to be based upon the experts, and now your experts' analysis, right?
He told me about concepts and he told me what he saw and didn't see. I want to ask him what he saw, and I think I can question him about what.
Well, no. Your expert, well, just in terms of just what you just said, your expert told you about what he didn't see, what he did see, right?
I want to ask him if he saw those things.
Well, I get you, counsel, but what I'm saying is your expert is giving you the framework for your questioning, right?
He didn't write my questions. He told me about concepts and what he saw.
I didn't say that he wrote your questions.
I don't even
That's not that's not what I'm asking. What I'm asking, let's try it this way. You know to ask the questions that you're asking because of your expert's analysis. Nothing wrong with that, but that's how you know what questions and what areas to probe into. That's fair, right? I mean, because that happens with any,
I'm not
right?
an expert
Right.
in outlook.
So if there's a report, a new report that just gets to the prosecutor, because well, let me back up. There was obviously a previous report, right?
Yes, Your Honor.
That then generated another report from Detective Parks, right?
That's correct, Your Honor.
Yeah, because that was the last part of the question.
Yes.
Now there's going to be your questions to Detective Parvis based upon a new report. And let me just ask this. I haven't seen the report or anything. Does that new report come to the same conclusions as your previous report?
Yes, but for different reasons.
Exactly. That's exactly what I was going to say. It comes to the same conclusion, but for different reasons. I think it would be highly unfair as we sit here today to, how long was this report?
I have a
I
copy.
think it's 15 pages, Your Honor.
Okay.
So the digital forensic report itself is 13 pages. Included with it was also the person's CV, as well as just a copy of an email correspondence.
And you're saying you just got this report
Thursday,
Thursday.
but evening, I believe, I'll double check. But again, we don't have to call the expert.
Right. But that's not the only issue, counsel. Part of the issue is you calling the expert. Part of the issue is, and I'm not saying anybody would be doing anything wrong, the way in which you frame the question, the context in which you're asking the question, which is going to be framed by, I would presume, that report. And then the response the response to the question may have significant bearing. Let me strike that. The context of your question may mean something very different to Detective Parvitz, which may then guide his answer. And so what I don't want is I don't want responses that are going to then be misconstrued in some way, especially when we're talking about expert testimony.
Can I respond? So we have an expert on the stand, an expert that presumably knows about the concepts I'm going to ask him about. I'm simply asking him about concepts such as, if you look at the server log, what was the source for the transmittal? Was it a certain type of source, or was it some other source? And I'm simply asking him what he observed. I don't know how this is unfair to an expert. And certainly if something is misconstrued or it needs to be clarified, the prosecutor can do that also.
Well, that's part of the problem. Certainly they could do that, but they've had the report for what, 3 days?
Got it almost at lunchtime on Friday. It's Tuesday, just about 2 o'clock. So no, I have not had time to read through it, Your Honor. Unfortunately, this is not my only matter that I have to work on.
And also, counsel, that you say that, let me ask this, because it may have been your intention, it may not have been. As I understand it, you had indicated to the people you were going to call this expert today.
I think you said he may call, yes.
Okay, May. Okay.
But I don't have to, and I won't. I just don't know how I could have my cross-examination curtailed by the fact that I got some information.
By what?
By the fact that I got information from someone who knows the topic. So, for instance, if this were like a skid mark case, and the issue is how long was the skid mark, and if an expert told me, hey, ask them this question, and I came in and asked the question, that's not unfair, and that's not. The defendant has a right to cross-examine, as you know, and so I think that right.
It would, counsel, that's a very simplistic analogy to this, because I don't think this isn't just a skid mark. If it were just a skid mark, then okay, you could do that. You're actually talking about rather complex things that then have to be arranged in a certain way to come to some type of conclusion. And that's part of the problem. Ms. Lonnie.
I just want to say that the people are not attempting to curtail the cross-examination of Detective Parvis in general. It's just with the late disclosure of new information that myself nor the detective have had time to review. It does not seem that the way forward today is to allow that. Now, if that is the hope, is to cross-examine with some of this new information, I'm sure we can find another date that allows everybody to be ready for it. But trial by surprise, the people do not believe is fair to either side. And having a hearing that conducts itself with sort of last second information that doesn't leave either side leaves one side unadequately or inadequately prepared to move forward does not seem to serve the interests of justice.
Your Honor, I didn't even have to give her a copy of this report. I could have just come in and asked my question. So I don't understand why me being upfront and trying to say, so I'm trying to convince the prosecutor to drop this case. Because I don't think it's my
Counsel, I understand. I'm
trying to share.
I'm not getting into anybody's strategy about why they're doing what they're doing. What I am getting into right now, though, is whether you should have, you did, right? And so then the question becomes, how do I balance this to make sure that not only you get a chance to ask questions fairly and get a proper response, but at the same time, also making sure that it's not mistaken. I mean, I also, counsel, I'll just say, I think it also behooves you not to have the responses misunderstood. Right? Because I don't care what anybody tries to say about the simplicity of your questions. I think you're going to be asking questions based on that report. Get it? Nothing wrong with that. But I also think, much as the prosecutor might be concerned that a response that comes from Detective Parvis is subject to being misconstrued because he hasn't read the report, you're also may have a question that you want a response to that Detective Parvis isn't going to be able to say, well, I didn't read that report that you're talking about. So,
So my response to that, Judge, is that if I ask a question and he isn't sure of the context, or he can easily qualify his answer and say, yes, well, it depends on all these different things. And if he hasn't seen any report, then he could do that. I don't.
certainly you could. But the problem is the universe that the question is being answered in now has just expanded.
Well,
And
can I respond to that last part?
sure.
I don't think it's expanded, Judge, because it's all going to be based on a server log that they had since 2023. You know, they had the information. They should have looked at it. They should have understood it, and they didn't. They misconstrued it. And I want to ask questions about that without giving necessarily Detective Parvis a chance to try to figure out some way around it. Honestly, and in fact, I didn't even hold back. I gave them the report to them on Friday as soon as I was able to read it and give it to them. I did not hold back on the report. And I have, by the way, I have Mr. Greenberg. He's in court today, the fellow who wrote the report. If you have any, if you want to ask him about the timing, but I assure you that I did not hold back on this report.
I'm not saying that you are. That's not my issue.
We just really don't want to put this over. This is what Ms. Carey said there.
What?
We don't want to put this over, that's all I'm saying.
All right, I get that. But I also set aside a half a day because you told me that you wanted to do whatever. I get this when I walked in. And regardless of whether one wants to or not, I'm going to do
Of course.
make sure that it's a fair proceeding. That's what I'm going to do. So, Ms. Lundy, have you had an opportunity, and probably not, I just want to make sure to analyze even the CV?
Barely, Your Honor. I've glanced through it. I've looked at some of the work history and a little bit of the education. Detective Parvis and I had one phone call Friday in the lunch hour I let him know that it was coming. There was a new thing. He informed me he was at a week-long training last week and did not have a chance to look at it. And then I think we spoke again today before court. But other than that, I've just literally skimmed. I haven't had a good opportunity to analyze any of it.
And just looking at it, if one had the time, how much time, if I decided to go that way, would one need to be able to adequately have it, understand it, and respond?
May I have a moment? I am completely unavailable next week as I'm currently scheduled to do a week-long murder trial in front of Judge Conlon with Emmons. So I'm not available next week. I could actually look at the week of 14th to the 21st, but the challenge too is Detective Parvis currently, as he shared with me, and I asked if it was okay if I shared permission. He is currently 6 months behind. There's no new work with CSAM cases, CSC cases, homicide cases, robberies, armed robberies, all sorts of different things requiring forensic analysis. So I think we're looking at August for us both to be ready.
So what, rather than indicating the exact day, between the time of or you told me when you received it. When did you request this expert analyze anything?
I didn't. It was a fellow who came forward, who lives in the township. Right? Lives in Scioto Township. The expert is from Scioto Township. He came forward and provided the reports to my client, who provided them to me. So that's how it happened. And I didn't.
Gotcha.
So it's not.
Okay, it's not like you went out and hired an expert. You
No,
just,
he's not a hired expert right at this point. He's a concerned citizen that knew that he is an expert, but he wanted to provide his.
well, so that I'm clear. The citizen of Scioto
Yes,
reached out to your client.
I don't know how that worked, but I can ask him. He's here if you want to.
Well, I'm just trying to figure out how it came about and when it came about.
Can I have a moment here?
Sure. Counsel, when you're talking, you may want to hit the, so that it has to flash, it has to be green, so you have to hold it. There you go.
Thank you. I think I understand.
Right.
So my client had FOIA some information. She did a FOIA to get information, and she found an email that contained additional server information that
Hold on. Your client did a FOIA to whom?
to Washington County Sheriff. No, sorry.
To Scioto, so to speak,
Yeah, that's fine. To Scioto.
Scioto Township. Going back a couple of years, and I found an email from our IT, Chris Bailey, to N1 Discovery stating, here is all the information. N1 Discovery is what Scioto Township had hired an expert forensic, and it was the same information that they provided to the sheriff department. And this was back in early 2024. And I didn't know about this. Apparently the sheriff had it based on Chris Bailey's email to this person with N1 Discovery.
Okay, I don't want evidence of anything. I'm just trying to figure out, you get that information. What did you then do with that information?
I found the information and I had questions, so I called Jonathan because he is an expert in Outlook and Microsoft 365. I didn't know what I was
And
looking
Jonathan is the person that prepared
Mr.
this
Greenberg.
report.
Mr. Greenberg.
He's the one that did the newest report, Judge.
The newest, right? That's what I'm saying.
Gave me the information to ask the questions today, like I said.
Okay, all right. Court is standing in brief recess. I'll come back and give my decision as to whether or not we'll proceed today.
Thank you, Your Honor.
Thank you, Judge.
All rise.
I think he's coming. Wait. Don't let me do that.
It's because I see for 20 minutes.
Yeah, grab it.
So, yes, I mean, it was as safe as I could make. It wasn't. Let's have it for the E6 version. All right. 14A District Court of the County of Washington, State of Michigan is now back in session. Your Honor, Judge Jason.
Maybe see. Okay, the issue has come up regarding this new report. As I would if people came up with additional evidence and defense were in a position to potentially not be prepared to address it, I would adjourn it out. And I think only in fairness can I do that here. To adjourn these proceedings, allow them to analyze the information that's been presented to them. And then formulate what may be redirect, quite frankly, of Detective Parvis if necessary. So I analyzed it in my head in a lot of different ways. This is not any necessarily so concerned because other types of those derived from counsel doing that. And it's clear to me that this did not derive from counsel. which I think also causes at least some pause in terms of that, because I don't frankly know, and I'm not asking whether or not counsel, because he's the one that has to make the representations to the court and to other things, has had his adequate opportunity to vet what's there. So that is also a concern of mine.
Sorry, I didn't hear the last part, Your Honor. I apologize. I didn't hear that last part. You're concerned that I didn't do what?
To vet what's there. The timing of all of it is very odd to me.
Okay, yeah.
Okay, and so
Okay.
that's also a concern for the court, in fairness to the defense, in terms of the questioning. So, I mean, there's a lot that's kind of going on here. And so from my standpoint, I'm going to take the approach, well, it certainly may delay the proceedings. I'm going to do my best to try to make sure that it's fair. So,
Can I be heard just to make my objection for the record? For the record, this adjournment is over my client's objection. And I want to say
what's the
that,
basis of the objection?
sorry?
What's
Oh,
the basis?
her objection is her Sixth Amendment right to cross-examine and confront the witness against her.
That is not being compliant.
Okay, sorry, I'll let you finish. Let me know when I can talk, because I just want to make a record. I will.
Yeah, but you're making a record of things that don't exist.
Okay, but
Are you indicating that the court is taking away her Sixth Amendment right to cross-examine this witness?
I'm indicating that by essentially sua sponte moving this proceeding, the court is intervening and moving this hearing in a case where I was not going to even introduce the expert's testimony or his report. So the court is moving this to give essentially an advantage to the other side. So that's, I'm making my record.
Recess.
District Court for the County of Washington, State of Michigan is now back in session. The Honorable Judge J. Simpson will drive.
Maybe she. Back on the record in the case of the People's State of Michigan versus Julian Carey. Counsel, you wanted to place stuff on the record. Go ahead.
Yes, Your Honor, sorry. I just wanted to say for the record that this particular case, I think that the adjournment infringes upon my client's rights under the 6th and 14th Amendment. The 6th Amendment being her right to confront and cross-examine accusers against her without any intervention by the court. And the other one would be that the 14th Amendment right of due process for the court not to be fair and impartial. Those two, I just want to put those on the record, Your Honor, and I'm not trying to be adversarial. Thank you.
I don't need a response from people in terms of that. I noticed that you're noticing that for the record. So first of all, before I left the bench, you incorrectly asserted that the court is adjourning these proceedings sua sponte. This adjournment is after due consideration by the court based upon the prosecutor's request to do that. That is not sua sponte, and I'm sure that you would understand that being a lawyer, that it was not the court's, it's the court's decision, but it was not the court's motion to do it. So that's the first error that you made. There is no violation of defendant's Sixth Amendment rights in this case because the court is not interfering in the right to cross-examine. The court is going to permit effective cross-examination to the extent you can be effective of the witness at a later date. There is no interference. This delay in these proceedings has no effect on that whatsoever. I don't even know how you bottle that up to try to say in some way this court is interfering with her Sixth Amendment right to confrontation and cross-examination of witnesses. Further, in regard to, and I assume as an attorney, you know what due process means, and that means that the court has to be fair to all parties, not just to you, not just to give some benefit to defense. The court considered everything that was raised my own questions about the new report, whether or not that would be prejudicial to the people, whether or not it'd be prejudicial to the defense, weighed that, went back, took time, looked at it, would prefer to go today. Set aside the time at your request, counsel, from the last hearing, that I have a blanket time so that it wasn't with other cases to hear it. I set aside the time to do it. That's part of due process. Part of due process also is making sure that each side has a fair and adequate opportunity to do what they need to do in this case. It has. Now, those are the legal issues. What incensed this court, quite frankly, because it's something that I take very seriously, is the notion that this court has done anything, ever. And in my 25, almost 26 years, I've never been accused of that. Nobody has said that I have done anything to give one side an advantage over the other. It is not me. And I think, counsel, as you've proceeded through this case, you have seen that. I have never done anything that has said that people are going to have this advantage or to the people that you're going to have this advantage. I call it straight down the line. You get to present your case. I make my ruling. That's how I work. That's how I've always worked. So I will tell you that this court takes great offense when there is any indication that that's what this court is doing, that this court has any untoward motivation in doing what it's doing. That's my.
You want to respond to that?
At your own peril, counsel.
And to say, I appreciate the court finding that today, no other cases. I think I really appreciated that. That's why I wanted to get this on today. I mean, I think that if there were a legal reason for the court to put it over, then I would understand it. I just don't know what the legal reason is, since the
legal reason is exactly what you brought up: due process and fairness to the parties. Prosecutor raised an issue. I've gone through that, counsel.
Okay, I'm done.
Is there anything else you want to say besides trying to waste my time?
I'm not trying to waste your time. I have nothing else to say. Thank you, Your Honor.
Preliminary examination in this matter will be adjourned. August 12, 2025, 2 p.m. That's before me. We will go that day, folks. Even if we have to be here all evening, we will go that day.
Michigan is now in session. All those have business here, the Honorable Judge Simpsons.
May be seated. Come on.
Good morning, Your Honor. Actually, allowed me for the people at this time. Any conflict in this on report in the Office of Public Defender. The people do not believe that any conflict exists. We have people spelled out.
All right, very good. And Ms. Perry.
Good morning. This is Public Defender Lauren Perry, the Public Defender's Office. Likewise, does not believe the conflict exists, but if one does, we also.
All right. The court for its part also does not believe there's conflict either in admission court rules or the case is decided thereunder to the extent a conflict does exist, given the way the court will consent to hear the matters. Court does call the cases of the people versus Timothy Haslam.
Good morning, Your Honor. Christina Berry Deering, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Londy.
Permission to practice is granted.
Christina Berry Deering for the people. Good morning. This is the Public Defender Lauren Perry on behalf of Mr. Haslam. I suppose on the two cases he's already been arraigned on, ending in 04091621. Mr. Haslam, can you state your name, please?
Timothy Haslam.
All right, sir. You are up on two cases today. There is another case that is before the court that I'm going to arraign you on at this point in time, sir. And it's a 2-count complaint that alleges that on or about October 26, 2024, at the location of Washtenaw Avenue and Gulfside in Pittsfield Township, Washtenaw County, State of Michigan. Count 1 alleges that you operated a motor vehicle without proper security or insurance as required by statute. Do you understand the nature of that charge, sir?
Yes.
It's a misdemeanor punishable by not more than 1 year incarceration and or not less than $200 nor more than $500 fines plus court costs. Do you understand that, sir?
Yes.
Count 2 is the offense of driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand the nature of that charge and its maximum penalty, sir?
Yes.
First question I have for you is, do you wish to be represented by an attorney?
Yes.
public defender case.
Your Honor, on this case, I'd wait for the reading statement to the charges. I would ask for another pretrial. I did receive an offer from Ms. Landy. I just need some time to speak with that about Mr. Haslam, but we do have resolutions on the other two cases.
All right. 7-2, correct?
Yes, sir.
All right. So on this case, I'll set his bond at a $1,000, 10% bond. I'll adjourn the pretrial this is on 7/21. I'll adjourn the pretrial on my next.
July 16th, 2025.
July 16, 2025, 9 a.m. All right, that takes care of that matter. And then on the other two cases, what's our resolution?
Well, on the case ending in 0409, that is a sentencing. I think the court set it for today for convenience sake.
Okay. Well, no, is it? I don't either. You're saying 409?
Yes.
I don't have that as a sentencing. Well, he did plead guilty as charged.
So I don't believe that sentencing information.
I do. Yeah, it should be a sentencing. Before October 16, 2024, he pled, referred him to probation. November, we came back, we had to re-refer him because he didn't do that. And then from that point in time, he has bench warranted or we've adjourned it out.
I think the PSI was completed with Ms. Pilar. I have one from May.
I did complete a PSI because Mr. Haslam was in custody. I can pull that to the court would like to take care of that today. I believe it was a recommendation for credit for time, sir.
Yeah.
Well, he's got to come back on the 16th, so I'll
Okay.
just put this over to the 16th.
Perfect, that's even better.
You can just- And what are we doing on the other matter?
The other one is going to be a double parking resolution, Your Honor.
That's correct, Your Honor. So I move that count to double parking, case 241-1621. You accept that admission to double parking and dismiss your original charge.
Mr. Haslam?
Yes.
All right. Do you admit responsibility to the fact that on or about November 25, 2024, location in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. That'll be fines and costs of $180. That'll be due 60 days after release.
Okay.
All right. Thank you.
Thank you.
Thank you, Mr. Haslam. We'll see you in a couple weeks. Court calls the case People versus Nicholas Stimmel.
Christina Richardson for the people.
And good morning, Your Honor. Rita Young, appearing on behalf of Mr. Nicholas Stimmel, who's also present by Zoom. Sir, would you state your name for the judge, please?
Nicholas Stimmel.
Good morning. All right. What are we doing?
Judge, I just received late yesterday afternoon the paper discovery and video discovery. I did send the paper discovery to my client, but we both need to see the video discovery before we decide our course of action. So asking for one adjournment of the pretrial.
Hearing no objection, I'll adjourn this matter to July 16, 2025, 9 a.m. Bond will continue. Thank you.
Judge? Ooh.
Yes. Yeah. Of course, you're not available. You're in trial in Wayne County.
Can we go further in July, please, sir?
I knew it when I called out the date. I said that she's going to tell me she's busy. What's my next date?
August 6th.
Next date is August 6th, 2025, 9 a.m. I'm not moving that, counsel. If you got something said August 6th, you have them move it.
Yes, sir.
All right. On continue.
Thank you.
Thank you.
Mr. Sim, I'll give you a call. You can sign off now.
Court calls the case People versus Adam Soward. Excuse me.
For hearing for the people.
I'm sorry.
This is Mr. Timothy Diamond, who is busy out here, so.
I can go see if he's in the hallway. What's the last name?
Ryan.
That's the attorney.
Yes, sir.
Good morning, Your Honor. Timothy Dinan, P49499, appearing on behalf of my client who is on his way here. Judge, he had a late start this morning. My apologies.
I'll pass it.
Thank you, sir.
Court calls case People versus Kathy Johnson.
Ready, Your Honor.
That's a lot of people.
Good morning, Your Honor. Tim Hensick appearing on behalf and in the company of the defendant, Kathy Johnson.
Your name?
Kathy Renee Johnson.
All right. As to the arraignment on this council, has he been arraigned?
Yeah, I think we were here for 17.
I thought we were too. Let me pass this matter. Court calls case People versus Ricky Ballard.
Good morning, Your Honor. Robin McCoy, P63057, on behalf of Mr. Ricky Ballard. Your Honor, may we briefly approach?
Yes, Your Honor. As to the arraignment council.
He'll stand mute and waive the reading of the information.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea.
And Your Honor, I just want to make sure that the court is aware that my client, he has been taking this very seriously. He's had no prior conviction of this sort. So he's attending AA classes, and we did provide verification to the prosecution. He's scheduled for a substance abuse assessment on July 15th through First Step referral services, and he'll be attending an impact panel on July 14th at 7 o'clock at Bethesda. So we are still in plea negotiations, so we're requesting that this be adjourned so that we have, more time to try to work something out.
During this matter, July 16th, 2025.
Wait.
9 a.m.
The 16th, will it be 9 a.m.? It'll be in person?
In person.
Okay, I have a Zoom at 8:30, but okay, that's fine. So 9 o'clock.
As to bond.
Your Honor, we are requesting a sober link at this time. The defendant.
What is the alleged BAC?
0.179. He was over for speeding 25 over the limit. No priors.
No accident.
No accident.
And Your Honor, he is taking this very seriously. He's gainfully employed. He's married. He has 3 kids, and his family is counting on him to deal with these issues. He had some trauma from his youth, so he was in counseling, and he's making efforts to get back into counseling to address these issues. So we would ask that he not be placed on a sober link at this time.
Defendant's bond is set in the amount of $20,000 personal recognizance bond, all other standard conditions, including no assaultive behavior. There should be no use of alcohol, recreational marijuana, or any illegal drug. I am going to order that the defendant report to the Department of Community Corrections for placement on a sober link testing device. I've signed that order. He should probably appear within the next 24 hours. And we'll see everybody on the 16th. Thank you. Court does call the case. People, do I have it all there?
Yes.
Kathy Johnson.
That's
We
a lot
call
of people.
Kathy Johnson. My apologies for that, folks. My file should have been ready. All right. Sir, have you read over the pre-sentence report?
Your Honor, we have read over the pre-sentence report and recommendation. We have no corrections, deletions, or additions. I would like to make comments on behalf of Ms. Johnson before the court imposes a sentence.
You may proceed, sir. Was there anything from the people on this?
Your Honor, we would support and ask the court to adopt probation's recommendation as written.
All right. Go ahead.
Judge, with respect to the recommendation, it is fair, it is appropriate. However, there are some things the court should know. One, this incident was triggered by a personal health scare for Ms. Johnson. She had a diagnosis of a breast cancer potential, and this particular event comes on the heels of 2 that occurred more than 22 years ago. There have been no appearances in court. There have been no steps taken by her since back in 2001 and 2002 on the previous situations. Kathy works 2 different jobs, Your Honor, to support herself. Coming here today, she has made arrangements to immediately serve at least the minimum jail sentence, taking time off from her jobs. I have come to know her since being involved as her attorney as a very responsible lady who understands the gravity of what occurred here. She has participated in Dawn Farm, been here cooperating with the court, with probation, with whomever at every step of the way. I think, Your Honor, that the court should show some kind of leniency in terms of the fines and costs to allow her time to make payment. They total over $2,000, 24 months of probation. she just needs time to pay. And Your Honor, I believe that she would like to make a statement on her own to the court.
Okay.
You can go ahead.
My name is Catherine A. Johnson. I realized I made a mistake because I could have harmed other people. And I've been attending AA meetings, and I put myself in Domino's firm on my own. And I've been working 2 jobs. And I realized I made a mistake, and I'm sorry for what I've done.
Court does acknowledge it's not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart with the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, AA attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. It is the sentence of the court. You're placed on 24 months of probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When can that be paid? How are you going to pay that?
I'm gonna pay it when I get paid, if I can. On a monthly thing, I would like to be I would like to be
How much do you believe you can afford to pay of that per month, man?
at least $100 a month.
Pardon?
I could pay $100 a month. My check is being garnished right now.
I think we'll be able to. All right. I'll set your payment plan at $100 per month. That will begin in August. It may be readjusted by probation just to make sure that you're going to be able to get that all paid prior to the point in time of the end of your probation. There should be no alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You'd complete the non-farm outpatient program, including all recommended aftercare with status reports to probation. You're to attend 1 AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Mr. Allen. I'll order 365 days in jail, credit for 1 day served. I will remand you to the Washington County Jail to serve an additional 4 days, and then the balance will be suspended. Defendant is remanded. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Alexis Berry.
Prisoner hearing for the people.
Assistant Public Defender Natalie Patewick, on behalf of Alexis Berry, who appears via Zoom, can you please state your name for the record?
Alexis Berry.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have had a discussion again with Ms. Berry yesterday, and I did discuss this with the people. I'm asking for an adjournment for Ms. Berry to stay in compliance with bond and potentially earn a reduction in potential resolution.
I understand that. Would an August date work better for you then?
I believe so, yes, Your Honor.
During the matter, August 6, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Court calls case People versus James Bowman.
Prisoner hearing for the people.
Assistant Public Defender Natalie Patewick, on behalf of Mr. Bowman, who is present via Zoom. Sir, can you please state your name for the court?
James Bowman.
Thank you, Your Honor. There has been an offer extended in this case by the people for him to plead to count 1 and in exchange count 2 would be dismissed. I have discussed that with him. However, I have discussed this further with the people, and there's some information I'd like to provide them with and potentially come to a different resolution.
July
Thank you, Your
16,
Honor.
2025, 9 a.m. Bond continue.
Thank you, Mr. Bowman. You're all set for today.
Court does call the case People versus Jason Brooks.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brooks. Mr. Brooks, please state your name for the record.
Jason Brooks.
All right, thank you.
We're asking you to set this for final settlement, please.
Jury final settlement conference will be set for August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in-person proceedings. Thank you. Bond continued. Court calls case People versus Kyle Burmeister.
Assistant Public Defender Natalie Patewick, on behalf of Mr. Burmeister, who should be present via Zoom. Sir, can you please turn on your camera, unmute, and state your name for the court?
Kyle Burmeister.
I'm trying to turn the camera off. I'm here.
Can you please state your name, sir?
Kyle Burmeister.
At this time, Your Honor, the people move to dismiss.
Okay.
No objection, Your Honor.
Case is dismissed.
Thank you.
Thank you, sir.
Thank you, Mr. Burmeister. You're all set.
Thank you.
Court calls case People versus Tario Abdul Salam.
That's a lot of the people.
Abdul Salam, not present. I'll issue an order to show cause. Court calls the case of the People versus Abdallah Badr.
Christina Bear, there's people.
It's already issued. Badr. No response. A bench warrant will issue for the defendant's failure to appear. Bond in this case will be set in the amount of $5,000, 10% bond. That warrant will issue immediately. Court does call the case of the People versus Luke Barrett. Luke Barrett. No response. I'll issue an order to show cause. Court calls case People versus Joseph Bogan.
That's a lot of the people.
Bogan. No response. I'll issue an order to show cause. Court calls case People versus Richard Bauer.
That's a lot of the people.
Richard Bauer. No response. I'll issue an order to show cause. My apologies for that, folks. My files should have been ready. All right. Sir, have you read over the pre-sentence report?
Your Honor, we have read over the pre-sentence report and recommendation. We have no corrections, deletions, or additions. I would like to make comments on behalf of Ms. Johnson before the court imposes sentence.
You may proceed, sir. Was there anything from the people on this? Alcohol screening and assessment identifies the benefit of outpatient treatment, AA attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is the sentence of the court. You're placed on 24 months of probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When can that be paid? How are you going to pay that?
I'm gonna pay it when I get paid, if I can. On a monthly thing, I would like to be on, I would like to be on,
How much do you believe you can afford to pay of that per month, man?
at least $100 a month.
Pardon?
I could pay $100 a month.
All right.
My check is being garnished right now.
I think we'll be able to, all right. I'll set your payment plan at $100 per month. That will begin in August. It may be readjusted by probation just to make sure that you're gonna be able to get that all paid prior to the point in time of the end of your probation. There should be no alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You'd complete the non-farm outpatient program, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation, Mr. Allen. I'll order 365 days in jail, credit for 1 day served. I will remand you to the Washtenaw County Jail to serve an additional 4 days, and then the balance will be suspended. Defendant is remanded. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Alexis Berry.
Christina Bear, hearing for the people.
Assistant Public Defender Natalie Pate with and on behalf of Alexis Berry, who appears via Zoom. Can you please state your name for the record?
Alexis Berry.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have had a discussion again with Ms. Berry yesterday, and I did discuss this with the people. I'm asking for an adjournment for Ms. Berry to stay in compliance with bond and potentially earn a reduction in potential resolution.
I understand that. Would an August date work better for you then?
I believe so, yes, Your Honor.
During the matter, August 6, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case People versus James Bowman.
Christina Berry for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bowman, who is present via Zoom. Sir, can you please state your name for the court?
James Bowman.
Thank you, Your Honor. There has been an offer extended in this case by the people for him to plead to count one and in exchange count two would be dismissed. I have discussed that with him. However, I have discussed this further with the people and there's some information I'd like to provide them with and potentially come to a different resolution.
July
Thank you, Your
16,
Honor.
2025, 9 a.m. Bond continued.
Thank you, Mr. Bowman. You're all set for today.
Court does call the case People versus Jason Brooks.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Brooks. Mr. Brooks, please state your name for the record.
Jason Brooks.
All right, thank you.
And we're asking you to set this for final settlement, please.
Jury final settlement conference will be set for August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in-person proceedings. Thank you. Bond continued. Court calls case People versus Kyle Burmeister.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burmeister, who should be present via Zoom. Sir, can you please turn on your camera, unmute, and state your name for the court?
Kyle Burmeister.
I'm trying to turn the camera off. I'm here.
Can you please state your name, sir?
Kyle Burmeister.
At this time, Your Honor, the people move to dismiss.
Okay.
No objection, Your Honor.
Case is dismissed.
Thank you.
Thank you, sir.
Thank you, Mr. Burmeister. You're all set.
Thank you.
Court calls case People versus Tario Abdul Salam.
That's the line for the people.
Abdul Salam, not present. I'll issue an order to show cause. Court calls the case of the People versus Abdallah Bader.
Christina Bear.
It's already issued cause for viewing. Bader. No response. A bench warrant will issue for the defendant's failure to appear. Bond in this case will be set in the amount of $5,000, 10% bond. That warrant will issue immediately. Court does call the case of the People versus Luke Barrett. Luke Barrett. No response. I'll issue an order to show cause. Court calls case People versus Joseph Bogan.
That's the line for the people.
Bogan. No response. I'll issue an order to show cause. Court calls case People versus Richard Bauer.
That's the line for the people.
Richard Bauer. No response. I'll issue an order to show cause. I'm guilty.
Thank you.
Court does call the case of the People versus Lisa Keebler. Court does call the case of the People versus Lisa Keebler.
Christina. Yeah.
Okay.
Good morning, Your Honor. John Shea appearing within on behalf of Ms. Keebler.
Lisa Keebler.
Your Honor, the people and the defense have
arrived at a resolution of this case. We're presenting the court the paperwork attesting to that, and Ms. Keebler stands ready to proceed as described in the. You want to may approach briefly?
Yes, you may.
Thank you. Thank you, Your Honor, for that.
Record should reflect we've had a brief bench conference. In this case. Quick one, the court indicates that the defendant would be pleading guilty to the charge of operating while impaired. The 93-day offense upon a successful plea, count one would be dismissed. That is the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Yes, it is, Judge. Thank you.
All right. Very good. May I have the defendant's sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Lisa Keebler.
Skeebler, this court's understanding you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, a $500 or $300 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
I do.
All right. And understanding all of that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. All right. You signed in, is that correct?
Yes.
Yeah.
Any question regarding any of those rights?
No.
All right. Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on it.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. And because you believe that you are indeed guilty?
Yes.
All right. On June 29, 2024, at the location of 8265 Dexter Chelsea Road in Scioto Township, Washington County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I had.
And that was evidenced by an intoxilizer result or blood test result?
It's a blood test result, Your Honor.
A blood test result?
Yes.
Counsel, it's the court's understanding that the parties are stipulating to a 0.194
That's correct.
blood alcohol.
Yes, Your Honor.
All right. And Ms. Keebler, you don't have any reason to dispute that
No.
result. All right. Why did the police pull you over?
I hit a mailbox.
All right. So there was an accident of some kind. All right. And the police arrived.
Yes.
And that's how the blood test was taken. Ultimately, you were arrested. That's how the blood test was taken.
Correct.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Prior to accepting your plea, I do have to advise you that if you commit misconduct as defined under the court rule from the time I accept your plea to the time of sentencing, that any agreement regarding sentencing or any evaluation, the court would not be bound by. You understand that? Ma'am?
Yes.
You also could, if you commit that misconduct, could not use that or would not be permitted to withdraw your plea. You understand that?
Yes.
Counsel, do you know of any other promises, threats, or inducements which have led to this plea?
No, Your Honor.
No, Judge.
And have I complied with the court rule? Would it be proper to accept this defendant?
Yes, Your Honor.
Yes, it would.
The court will accept the defendant's plea of guilty to count 2. Should put that in a different spot. Count 1 is dismissed. Defendant is referred to probation. Oh, excuse me, I'm sorry. She's referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 30th, 2025 at 12 p.m.
July 30th, 2025, 12 noon.
Thank you, Judge.
Thank you.
Thank you.
Okay.
Case of the People versus Adam Sauer.
People.
Good morning, Your Honor.
Morning.
Timothy Dinan, P 49499. I'm here on behalf of Mr. Howard, who now appears on my right.
Your name, sir?
Adam Swords.
All right. What are we doing?
Oh, Your Honor, this morning I spoke with counsel and my client's asking to tender a plea of no contest to the charge. I understand that people do not have an objection to that and have forwarded the court a copy of the police report.
That's correct, Your Honor.
This is the one that was sent to me. Okay. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
Adam Swords.
Sir, it is this court's understanding that you're going to plead no contest to the charge of operating motor vehicle without security. That's a misdemeanor punishable by up to 1 year incarceration, not less than a $200 nor more than $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
And understanding that you still wish to plead no contest?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure that you understand, and that means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
I understand, Your Honor.
Still want to plead any basis for no contest plea?
Civil litigation. Right?
Live. All right. Sir, to that charge, how do you plead?
No contest, Your
Now,
Honor.
you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
It's you signed an advice right.
I believe we tendered it last time, Your Honor, to the court. If need be, I have gone over his rights with him, though.
Yes. All right. We could, yes, have.
Happy to do so, Judge. Let's look at everybody. In July 2. Thank you. You know, he's executed that.
All right. You have any questions regarding any of those rights on that form?
Oh, Your Honor.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of trial. By pleading guilty, you'll be giving up those rights as well as all the rights on the form.
I understand, Your
You
Honor.
understand you're giving up your right to appeal of right?
I understand, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's in state? Well, promise you anything to get you to plead guilty?
Just what we agreed to, Your Honor.
No contest, but Your Honor.
Gotcha. Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has received and reviewed Pittsfield Township Department of Public Safety report for their case number 253831. Any objection to the court having reviewed that report?
None, Your Honor.
Is counsel aware of any inducements, promises, threats that have led to this plea, other than what's been stated on the record?
No, Your Honor.
No, Your Honor.
All right. And the court does not believe that the admonishment regarding misconduct will be necessary because I'm going to immediately sentence him. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
It would be proper, Your Honor.
Court will accept the defendant's plea of no contest to this charge. Anything, counsel, you or your client want to say before I impose sentence?
Judge, my client has a clean criminal record. He's had some financial problems as of recent. He is self-employed. He's also had a lengthy separation from his family. His wife left the country essentially with his children, and it's been a challenge. All the vehicles he drives now are properly insured and properly licensed. And I think my client's earned a valuable, if not a very expensive lesson.
Sir, anything you want to tell me?
I believe my attorney represented it very well, but thank you, Your Honor.
Fines and costs of $300, a loader 365 days in jail that is suspended. When do you think you can get that paid, sir?
We should pay $300, buddy. 2 weeks.
Yeah, that's okay.
Your Honor, if you can just give us 14 days, that'll be plenty of time.
That stuff happens. So August 1st.
Thank you, Judge.
You're welcome.
Have a good day.
Thank you.
Thanks for your help today.
Is that it, sir? Block?
Thank you, Your Honor.
All right. That's it for that block. I'll take a brief recess. We'll come back. We'll start our time.
All rise.
Oh, sorry.
You got
Yeah.
You may be seated. Did Simon kick you?
No, I ran into that.
That's my finding. Anyway. Yeah, we have to. Court calls case of the people versus Jacob Treadway.
Conrad Silver on behalf of Pittsfield Township.
Your Honor, Joe Simon, on behalf of Mr. Treadway. Jacob, state your name when you get up here.
My name is Jacob Treadway, Your Honor.
All right.
Your Honor, for arraignment purposes, we waive formal reading and stand mute.
And the name will waive formal reading, standing mute. Court will enter not guilty plea.
And regarding the pretrial, we've reached a resolution.
We have, Your Honor, the resolution is on at count 2, operating while visiting impaired. If the guilty that at count 2, accept that guilty plea to count 1. In addition, there is a PBT refusal civil infraction case before this court I think it's.
You guys are gonna need to do the plea form for me. Normally I wouldn't require it, but they're the requirements of the court rules, so that he has to acknowledge in writing. So I'll have you fill that out. It's gonna be an additional dismissal of a citation. Needs to be noted on what's.
Oh, Your Honor, thank you. We'll do that, but I think Mr. Siller was just documenting what he's going to do in a different court. We're not
In
doing.
that case, it's not.
I understand.
Oh, okay. Okay, all right.
All right,
You need that number?
all right, I'll pass it on. You can have a seat, sir.
Thank you, Your Honor.
Court calls case People versus Vincent Dunlap.
People.
I think Mr. Stiller's on some of the other cases, but
Conrad Silver on behalf of Pittsfield Township.
sorry, Mr. Siller, handling a bunch of stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
Good morning, Your Honor. The please this honorable court, Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right, and what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all three cases to the civil infraction of a double parking.
That's correct, Your Honor.
Yeah, there's a state case that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. Deal fraud case. I'm a prosecutor for the EWS case.
That's why I thought I spoke with you earlier. Awkward.
Well, it looks like we do not have an agreement.
Then, Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back. Last time we adjourned it to see what was gonna happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
My cases are the cases with Mr. Siller, Your Honor, so I would, we are going
Double
to.
parking on both.
Correct.
Double parking in each case, Your Honor. I'm gonna move that count to in each case, double parking. If you accept that admission fee in each case, and it's the original charge.
That's a correct statement.
That is, Your Honor, thank you.
Dunlap?
Yes.
In case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
On the case ending in 354, on the date of April 2nd, 2021, do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes.
Court will accept those admissions in each case. Count two, count one is dismissed. In each case, fines and costs are $180, so that's a total amount of $360. That's to be paid 60 days. I'll make it 90 days after release.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Juliet von Oceanbear Martinez. This is Mr. Siller's case.
Conrad Silver on behalf of Pittsfield Township.
All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse counseling the court deems necessary. You understand that?
Right.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't
Is it
necessary.
necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez,
Yeah.
are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court, a court on any other things?
I am. But none of them are drug related. And they're about to be finished.
Well, maybe. What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like have it like
To do what?
have it go like is there any way to like forget about this somehow? Is there anything that I can do like community service or something that I could do instead of
Ms. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, knowing a little bit about your history, I don't know that would be a wise call on your part.
guess so. Like what like I suppose.
Ms. Martinez, just answer me this. Are you represented by the Public Defender's Office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like I can have this be adjourned with a bond. Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
No.
So,
I'm not protesting to the allegations. I would like to
well,
just,
but hold on. I don't want you saying anything about the offense.
well, I do. I see no way around it. It's plain and clear and simple. and
Well,
there's-
no, that's why people get attorneys, because sometimes they don't see any way around it.
But it's clear. It's plain. Like,
Well, I don't know that, Ms. Martinez.
yeah, I guess I'll go with the lawyer, sure.
You will, good. Okay, public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them.
Got
So
it.
I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that. All right.
The appointment is today?
When she has the appointment today.
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th and her bond is denied on that case. So
Got
I
it.
believe it's the 28th.
Okay, so what I will do is I'll adjourn this matter out to August 6, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right, thank you.
Thank you, Your Honor. Thank you, Ms.
Does-
Martinez.
Miss
I'll be
Ma'am, it says on the Forensic Center is coming to see me today?
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez. But you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pate. Thank you.
All right, thank you.
Thank you, Ms. Martinez.
Court does call the case, People versus Jacqueline Murray.
Kyle Brill on behalf of Ms. Murray. State your name for the record.
Jacqueline Murray.
All right, what are we doing?
And
No, the court should be in receipt of a plea form. The defendant will
I
be
just need to-
pleading guilty
Can you
to
just
count
sign
one
that real
retail
quick?
fraud in the second degree, count two, three here are going to be dismissed as well as a case in public district court.
and today is July 2nd, if you could. And Your Honor, I'm having Ms. Murray fill out the form right now, as well as
Fill out which?
the plea form.
So no, I'm not in receipt.
Not in receipt yet, no, as well as the, just sign that, as well as the advice of rights form. And if the court needs some help deciphering my handwriting, I'd be happy to provide it. But it's everything as Ms. Londy stated on the record, as well as an amount of restitution between the two cases for a total of $1,281.57.
I have that she's gonna be pleading to a retail fraud second. The 1-year offense. Is that what this is supposed to say?
That's put the wrong time.
All
there.
right.
Yeah, my apologies, Judge, that's the error.
And then, well, it's a 1-year offense.
Yes.
I get it, but then there is total amount of restitution. I see the 1281.57. And then that looks like it's off of 2 cases.
Yes, Judge,
This
that,
case and another case. And then it just says that the prosecutor and defense agree that they'll dismiss case 250021 in the 15th District Court.
Yes, Your Honor.
Have her sworn.
You solemnly swear and affirm the testimony about the whole truth and nothing but the truth. So help you God.
Yes,
State your name.
Jacqueline Murray.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the second degree.
Yes, Your Honor.
All right, that's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, I did, Your Honor.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright?
Yep.
Yes?
Yes.
Are you on probation or parole?
What? Am I on?
Yeah, are you currently on probation?
No. No, Your Honor.
Okay, let me try it again. I'll break it apart. Are you on probation?
No.
Are you on parole?
No.
All right. Has anybody promised you anything other
No.
than what's been stated here today on the record?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and also because you believe that you are indeed guilty of this.
Yes.
Between the dates of May 20th, 2019 and June 18th, 2019 at 3749 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Target?
Oh,
Makes you think that you're guilty.
I walked out with merchandise.
Okay, so you went into the store, you took merchandise and you walked out without paying for it?
Yes, Your Honor.
Was the store open to the public at the
Yes.
time? Did you have anybody's permission to take that property?
No, Your Honor.
And this property that you took, this was property that was offered for sale by Target?
Yes, Your Honor.
All right, is this on the value then?
Yes, Your Honor.
Was the total amount of property that you took from Target, was that in excess of $200?
Yes, Your Honor.
Counsel, have I complied with the court rule? I won't ask that. Ma'am, I do have to advise you that if I accept your plea and you commit some type of misconduct as defined by the Michigan court rules between the time I accept your plea and the time of sentencing, any type of sentencing agreement or evaluation of this case, the court is no longer bound by. You understand that?
Yes, Your Honor.
You also understand that because of that, if you also commit misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right, counsel, are you aware of any other inducements, promises, threats that have led to this plea?
No, Your Honor, and I will let the court know the defendant does have pending felony matters that are not a part of this agreement.
Yes, Judge, nothing else beyond what's been placed on the record. And, we did discuss the felony matters and we are aware that they're not part of this agreement.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
You are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
July 9th, 2025 at 10 a.m. At night.
July 9th, 8. Okay, July 9th, 2025. What time? 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
And we'll continue. Court calls case versus Nathan Bell.
Conrad Silver on behalf of the township.
Mr. Simmons.
Actually, want to proceed, please?
Cabral on behalf of Mr. Bell in both matters. So I was
here. No,
I don't believe so, Judge. Unless he's logged in on Zoom, I don't believe so, Your Honor. So I was just very recently appointed to this matter. I don't believe I have a good phone number for Mr. Bell. I'd ask at this time for either an adjournment or a show cause hearing to allow me time to send him a letter to hope to get in contact with him.
bench warrant will issue bond 5,000, 10% each case. Those warrants will issue immediately. He's had previous warrants.
Judge.
Court does call the case People versus Daryl Frederick.
Township.
Your name, sir? Daryl Frederick. All right. This is an arraignment. Sir, you are before the court on a new charge that alleges that on or about May 30th, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you were in possession of drug paraphernalia. You understand that charge, sir? Yes.
Yes, sir.
All right. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs, and any substance abuse counseling the court deems necessary. You understand that?
I do, Your Honor.
All right. First question that I have for you, sir, is do you wish to be represented by an attorney?
I do, Your Honor.
You do?
Sir.
Public defender, please.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, we would waive any further reading. My client stands mute and we would ask for an adjourned pretrial date, please.
And in every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned July 16th, 2025, 9 a.m. Bond in this case will be set in a amount of. Is this the only thing holding you, or you're held by?
No. Oh, sorry, Your Honor. No, he's being held on other matters, several, and he has court dates on the 8th and the 9th of this month, but also the 30th. So I'd ask for a nominal bond in this case.
Bond will be set in the amount of $1,000, up to 10% on that. Standard conditions including no assault behavior, no alcohol, recreational marijuana, or any illegal drugs. And I will put him on testing at community corrections 2 times per week. Placed.
Thank you, Your Honor.
Thank you. Court does call the case, recall the case, People versus Jacob Treadway.
Conrad Silver on behalf of Pittsfield Township.
Ready, Your Honor. Joe Simon on behalf of Mr. Treadway. Your Honor, they just informed me that Judge Freshour wants me to come next door right now, but I know this court is higher importance. No,
I am.
Yeah, so let's get this done.
All right.
And so, Your Honor, I think maybe we should start again. For the purpose of arraignment, waive formal reading and stand mute, pardon me.
And in every way, formal reading, standing mute, court will enter a not guilty plea. I have before me a plea form that indicates that he is pleading to the charge of operating while visibly impaired and added count 2, the 93-day, $300 offense. On a successful plea to that charge, then count 1 would be dismissed, as well as a civil infraction. The file noted a PBT review would also be dismissed.
That is correct, Your Honor.
All accurate, Your Honor.
Raise your right hand. You solemnly sworn to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. My name is Jacob Treadway, Your Honor.
All right, sir, it is this court's understanding that you're pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. Court could also order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yeah, I'm sorry, can you repeat that, Your Honor?
And you're doing this because you believe that you're guilty?
Yes, Your Honor.
April 18, 2025, at the location of State Street in Pittsfield Township, Washington County, State of Michigan, where you're operating a motor vehicle.
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had about 8 to 10 beers. 3 of them were tall, Your Honor.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police for speeding, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
You were taken to the station or the hospital?
I went to the station, then to the hospital, Your Honor.
All right. Was there a blood draw?
Yes, Your Honor.
And what were the results of that blood test?
It was .226, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, I do have to advise you that if I do accept your plea and you commit misconduct as defined by the court rule between the time of my acceptance of the plea and the time of sentencing, any sentence evaluation or recommendation is withdrawn and the court is not bound by that. You understand that, sir?
Yes, Your Honor.
You also understand that if you do commit that misconduct as defined, that you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that? Counsel, is counsel aware of any other promises, threats, or other inducements that have caused this plea?
No other promises, threats, or inducements.
No, Your Honor.
All right. And has the court complied with the court rule, or would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
The court will accept the defendant's plea of guilty to count 2.
Your Honor, if it matters to setting the sentencing date, my client's been screened, assessed. He's commenced on farm recovery group. He is about three sessions completed of that 36-week program.
Well, I'll do my standard referral to Von Schwartz for an alcohol screening assessment. You can check with probation as to whether or not they want to do that, but I'll make that referral to Von Schwartz and the Victims Impact Panel. Sentencing in this matter will be
July 30th, 2025.
July 30th, 2025, 12 p.m. Bond in this case will be set as a $25,000 personal recognizance bond, although the standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I am also ordering a community corrections order for testing on a SoberLink device at this time. All right,
Your Honor.
Anything further?
No.
No, Your Honor. So, but, okay.
Appreciate it, man.
Yep. See you out there. Go ahead. Yes, but just wait for me outside.
Court calls case People versus Matthew Fonseca.
Sorry.
All right, so we have to do township.
Did Joe have some-
For the people.
I did have, but
They'll wait for me.
they will wait for me.
They'll wait for me.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Lewis Fonseca.
I think we're here for a pretrial and an arraignment.
Yes. As to the arraignment, sir, there's a complaint that alleges that on or about June 4th, 2025, at location of Washington Avenue near Hogback in Pittsfield Township, that you did have in your possession drug paraphernalia. You understand that, sir?
Yes, I do.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse treatment the court deems necessary. Do you understand that?
Yes, I do.
First question I have for you on that is, do you wish to be represented by counsel?
Yes, I would like to.
This is a public defense.
We'll waive further reading, stand mute to the charges, and I'd request another pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 16th, 2025, 9 a.m. What are we doing on the other case?
I'd ask that it be set for the 16th as well. Mr. Fonseca has a felony that I've been in conversation with the people about. We're trying to do a global resolution.
All right. On the other matter, that being 751, I'll adjourn that to that same date of the 16th. As to his bond in the new case, I will set the defendant's bond at $5,000 personal recognizance bond under standard conditions, including no assaultive behavior or possession of any weapons. There should be no alcohol, recreational marijuana, or any illegal drugs. I will also order that the defendant is to report to the Department of Community Corrections for drug testing. That'd be 2 times per week. And I'm sure, and I'll leave it there. I would. I'm sure you are going to apprise your client of proper attire when he comes into the court.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Kevin Gibson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Devin Gibson, who is approaching. Please state your name for the record, sir.
Devin Gibson.
Thank you, Your Honor. I'm respectfully requesting an adjournment for 2 reasons. The one being that Mr. Gibson is being held on felony matters with his next court date being the 17th of this month. So I would ask for an adjournment after that date.
August 6, 2025.
Thank you, Your Honor. And the people did make an offer in this case Monday evening after I had met with Mr. Gibson that afternoon. I just still also need to discuss that with him. But thank you, Your Honor.
August 6. Thank you. Court does call the case People versus Jermaine Nathan. 3 cases.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Nathan, who is approaching.
Right, Nathan.
Thank you.
Thank you, Your Honor. As to the 2 state cases that end in 0897 and then 0898, I would respectfully be requesting an adjournment into August for Mr. Nathan to get a Secretary of State appointment.
Does he have it set already? Or
No, not to my understanding, Your Honor.
I'll adjourn those matters August 6, 2025, 9 a.m. Bond continued in those cases.
And then, Your Honor, as to the case ending, the Pittsfield Township case ending 0060, Mr. Siller had made an offer to dismiss the misdemeanor and allow Mr. Nathan to plead to or admit to the civil infraction of double parking. And I discussed that with Mr. Nathan, and he would like to do that today in that case.
That is correct.
Mr. Nathan, do you admit responsibility to the fact that on or about January 7th, 2017, location in Pittsfield Township, specifically Washington Avenue, that you double parked a motor vehicle?
Yes, sir.
Court will accept that admission to count 2. Count 1 is dismissed, and this is in the case ending in 0060. Fines and cost of $180. When can you pay that?
Get it done by next month.
By next month? When next month?
What's the date today? The 2nd?
The 2nd.
2nd of next month. I'll pay.
August, all right. Well, I'll make it August 4th. Okay?
Yes, sir.
Pay by August 4th, 2025. You're all set. Thank you. Court does call the case People versus Robin Muhammad.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Muhammad. Mr. Muhammad, please state your name.
Rahman Muhammad. Thank you.
We're asking you to set this for final settlement, please.
Jury final settlement conference will be set August 8th, 2025, 9 a.m. Jury selection will be set August 11th, 2025, 8:30. Both of those proceedings are in person. Bond will continue.
Thank you.
Court calls case of the People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Fox. Should be on Zoom, Your Honor.
Jessica Fox. I have a Jessica, but I have no idea if that's her. Ma'am, what's your name?
Jessica Lopez.
That's not her. Jessica Fox? There's no response.
Yeah, I did speak with her yesterday. We did have a resolution. However, we were gonna adjourn due to some further conversations. I did expect her to be here. I don't have an explanation for her failure to appear.
Bench warrant will issue bond 5,000, 10%. That warrant will issue immediately. Court does call the case People versus Barrage Scott.
It's still around the Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Barrage Scott, who is approaching. Please state your name for the record, sir.
Verizon, take Scott.
What are we doing?
Your Honor, I'm looking to dismiss the case. Mr. Scott has completed a drug treatment program to my satisfaction.
Any objection?
No objection, Your Honor.
Case is dismissed.
Thank you, Your Honor.
Court does call the case People versus Eric. Is it Canis? Case Casey?
Dr. Lonnie, for people. Raise it, Your Honor.
Hello, Your Honor.
Hello, your name?
Eric James Casey.
Sir, you're here on an arraignment on two charges. The complaint alleges that on or about July 18, 2024, at the location of
This courthouse.
33.
Yeah, it all happened in
Are
this
you
courthouse.
gonna interrupt
I'm
me?
sorry.
Are you gonna let me continue with your arraignment?
Okay, I'm sorry, sir.
Which way you want to do it?
I'm not gonna interrupt you.
Thank you. Complaint alleges that on or about July 18, 2024, at the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, complaint alleges that you did make an assault and battery upon a Joseph Crossley. Do you understand the nature of that charge, sir? And I'm not asking you whether or not you did it. Do you understand what you were charged with?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. This could be a consecutive sentence. And if a consecutive sentence can be imposed, if this did occur within a place of confinement, you understand the nature or the penalties in this case?
Yes.
You understand that?
Yes.
Count two on that complaint alleges that on that same date and at that same time, you did commit the offense of disorderly person jostling. You understand the nature of that, sir?
No, because I don't even know these people. The only person I know is
Do you
Joseph.
understand what you are charged with?
Well, I know what you're charging me with, sir, but
I am not charging you. Do you understand what you are charged with in count two?
no.
All right, let me just do it formally then. July 18, 2024, the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Count two specifically alleges that on that same day and at that same location that you were a disorderly person. To wit, a person was found to be jostling or roughly crowding people unnecessarily in a public place at that location. Do you understand all of that?
I understand all that.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand those penalties?
I understand this, Honor.
Do you wish to be represented by an attorney?
Yes, I guess so, Honor, because you
It's a
didn't let me
public
speak.
defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Casey, we would waive any further reading. My client stands mute and we would ask for an adjourned pre-trial date as well as a PR bond, please, Your Honor.
Defendant having waived for reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to July 16, 2025 at 9 a.m. I will set the defendant's bond in this case amount of a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. Do you understand that, sir?
Oh, yes.
Do you understand also that I am going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug?
Yes.
I will also order that you are not to have any contact whatsoever with Joseph Crossley.
Don't want to. I'm sorry, sir.
You are really wearing on
I'm sorry, sir. I'm just trying
me. Do
to.
you understand the order? That was a question. Do you
Yes,
understand you are to have no contact with Joseph Cross?
yes. I haven't had no, I'm sorry. I'm sorry. I'm sorry.
It's one more time.
I'm sorry.
I'm changing the bond.
I'm sorry.
Is there any other requests of conditions from the people?
There is a request for a no go to, Your Honor, an address. May I give that to the court?
No, go to, yes, go ahead.
10245 Talladay Road, Talladay in Willis, Michigan. 48191.
Any objection to that, council?
No, Your Honor.
All right, I'm going to order that there is no go to that location, 1025 Talladay Road, Willis. Thank you.
Thank you.
Thank you.
Sorry, Judge.
We may be off because they brought him out. You got Rayburn? I was just asking. Court calls case People versus Todd Rayburn.
Conrad Silver on behalf of the Township.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Rayberg, who is approaching. Mr. Rayberg, please state your name.
Todd Rayburn. Thank you.
Your Honor, we're asking for adjournments on both cases. Mr. Rayberg is going to be released to treatment, hopefully. We just coordinating all the cases to make sure that happens. So, and treatment is related to the resolution to these cases or this
Okay,
case.
you
So,
want an August date or the July date?
Maybe let's keep it on the 16th and just see what happens if that's okay with the
That's-
court.
July 16, 2025, 9 a.m. Bond will continue in each of these cases.
Thank you.
Thank you. Does call the case People versus Grant Ducia.
People.
Grant Ducia, no response, unless in order to show cause. Court does call the case People versus John Farrow. John Farrow. There's no response. I'll just add these to his additional like 13 other ones.
Yes, Your Honor.
Bench warrant will issue bond 5,000. Give a 10% privilege on it. Warrant will issue immediately. Court calls case People versus DeMar Ficklin.
That's one people.
Hello.
My name is DeMar Ficklin.
All right. Sir, this is an arraignment. You are before the court on a complaint that alleges that between the date October 4, 2024 and October 18, 2024, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that being the Meyer store, that you as an agent or trustee of that store did embezzle funds greater than or less than $200. You understand that charge, sir?
Yes.
All right. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become your maximum fine. You understand that? Okay, first question I have for you, do you wish to be represented by an attorney?
Yes.
See how easy that can be?
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Ficklin. We will waive further reading, stand mute, and ask for another pretrial date, Your Honor.
Defendant in every way, form, or reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned July 16, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond, all under standard conditions, including no assault of behavior or possession of any weapons. I'll also order that there's to be no alcohol no recreational marijuana or any illegal drugs. You understand that? Yes. All right. I will also indicate that the defendant is not to go to the 3825 watch. I'm going to order he's not to go to any Meyer in the state of Michigan. You understand that, sir?
Yes.
All right. Anything else?
Thank you.
Nothing, thank you.
All right. Who's here with you? Who's that?
My mom.
Mom? So after that last gentleman came up, your mom knew you were coming up for arraignment. Did she tell you how to act?
Yeah.
She did? And she probably said, don't do that?
Oh, yeah, yeah, yeah.
You got a wise mom. All right, thank you. Thank you, ma'am. Court calls the case, People versus Shania Williams.
Conrad Silver on behalf of this township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Williams, Miss Williams, excuse me, please state your name for the record.
Shania Williams.
All right.
Your Honor, Miss Williams being held on 2 other matters. She believes she may be getting out of custody on July 8th. So we're asking to set this
And
case.
a hope and a prayer, or she knows?
Well, we're
No.
not on that case, so I don't, it's a conflict case. So I'm just asking to set it after that. She's really wants to get her license back. And so if she's released, she'll work on that immediately.
July 16, 2025, 9 a.m.
Thank you.
All right, thank you. Court calls case People versus Cody Mahan.
Oh, really?
Cody Mahan. Kai Burdell on behalf of, but not with, Mr. Mahan. Unless he's on Zoom.
Ian, too.
So, Your Honor, today is the date and time set for pretrial. I was very recently appointed to this matter. I don't believe I have good contact information for Mr. Mahan. So we are asking at this time for an adjournment or a show cause hearing to allow me to send him a letter or try to otherwise get in contact.
And warrant will issue bond 5,000. Give 10% privilege, that warrant will issue.
Thank you, Judge.
Court calls case People versus Tony Gomez.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Gomez. I'm sorry. Mr. Gomez.
Good morning, Judge. Tony Gomez present. One moment, please, and I'll turn my camera on.
Thank you. Oh, where are you? There he is. Okay, gotcha. You're not driving, are you?
Negative, Judge. I just pulled over on the side of the road. That's why I wanted to take a moment.
All right, thank you. All right, what are we doing?
Your Honor, I am asking for an adjournment. I think the 16th date would be okay, if that's okay with the people in your honor. Ms. Lonnie's looking into if there's CCTV footage from this incident.
Got it. I'll adjourn the matter to July 16th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
All right, thank you, Mr. Gomez.
Thank you.
Court does call the case of the People versus Lamar Hampton.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hampton. Mr. Hampton, please state your name.
Mr. Hampton, Lamar Hampton.
All right, I need a camera.
Okay, I'm
What are we
fixing
doing?
right now. Can you see me now?
I got it. We got you.
All right.
A big old chain around your neck. Go ahead.
Your Honor, I am asking for an adjournment. I did speak with Ms. Lonnie about a resolution, but I was unable to reach Mr. Hampton about that resolution. So I just want to discuss that with him, please.
August 6th, 2025, 9 a.m. or as your invite indicates. Bond will continue. All right. Thank you, Mr. Hampton. Court calls case People versus Destin Hopkins.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hopkins.
Oh, there he is. State your name, sir.
Destin Hopkins.
Thank you.
Your Honor, Ms. Pate spoke with Mr. Hopkins. She is asking for an adjournment until after July 29th. Mr. Hopkins has a sentencing on a VOP in circuit court. I think she wants to know what's happening there.
August sixth, 2025, 9 a.m. Bond continued. Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Khalid Ishar.
Oh, Ashley Lundy for the people. I'm sorry, I had Issa as the last name. I apologize, sir.
Oh, it actually is. I don't know what Ishar Isa. All right.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Issa or Hishar Issa.
Isa.
Yes, Your Honor.
Oh, hello.
Hello,
Hello, what's your name?
Hishar Isa.
All right, I need a camera. Oh, there you are. Okay. All right. I've got him now.
Thank you, Your Honor. Sorry about that. I was in the hallway. Assistant Public Defender Natalie Pate with and on behalf of Mr. Issa, who is present here via Zoom. I have discussed this matter with my client, and we are respectfully requesting to set this case for final settlement conference.
Jury final settlement conference will be set August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person. All right. Thank you, sir. Bond continue.
Thank you, Your Honor. Thank you, Mr. Issa. You're all set for today, but we'll be in touch.
Court calls case People versus Sophia Banco.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Banco is present via Zoom and has stated her name. Your Honor, I have discussed this matter with my client and briefly with the people. I'm requesting an adjournment of at least 3 to 4 weeks for a referral.
During the matter, August 6th, 2025, 9 a.m. Bond with its conditions will continue. All right. Thank you, ma'am.
Thank you, Your Honor. Thank you, Ms. Sabanco. You're all set for today.
Court calls case People versus Jessica Lopez.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Lopez. Ms. Lopez, will you please state your name for the record?
Yes, Jessica Lopez.
Thank you.
Your Honor, we do have a resolution. Ms. Lopez will be pleading guilty of charge under prosecutor's deferred.
That is correct, Your Honor. There are no other agreements.
Do
you need that?
Oh,
I
right.
apologize.
I do because counsel approach so that you know why I have to do it this way. Because everybody wants to make judges' lives difficult. All right, we're back on the record in the Lopez matter. Ms. Lopez, what I'm going to do is I'm going to adjourn this out to July 16th, 2025, 9 a.m. Your counsel will explain why. It's no harm to you in that, but I'm going to put it out to that date. Okay, ma'am?
Okay,
Just a paperwork issue, Ms. Lopez.
all right.
The offer will be open at the next hearing.
All right. Thank you, ma'am.
Okay, bye.
Court does call the case People versus Chad Maurer.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Maurer. Mr. Maurer, please state your name.
Yeah, you're not going to do that.
Well, Your Honor.
Unless it comes from on high, but not in Zoom.
I did speak with him this week, and last week. He tried to join the Zoom yesterday. He was texting me, calling me that he couldn't get in. So I know his intention was to be here, but I don't have an explanation for his actual here.
Bench warrant will issue for defendant's failure to appear. Bond $5,000, give 10% privilege. I will, however, not issue that warrant till the 7th. Okay. You're welcome. Court does call the case People versus Kenneth Miller.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Miller. Mr. Miller, please state your name for the record.
Kenneth Miller. All right, thank you, sir.
Your Honor, we are requesting an adjournment for potential mitigation information to Ms. Londy. I would ask maybe for a little bit further than the 16th if possible. Mr. Miller is engaged in treatment.
Got it. Adjourn this to August 2025, 9 a.m.
Thank you, Your Honor.
Your Honor, may I
Yes, sir.
ask a question? I was wondering if I could if it would be possible to switch to the SoberLink from the tether? Because it's impeding me from being able to let my kids go to the pool because I can't get in to save them if they're gonna drown.
Wow. I'd have to hear that by motion or if it's arranged by stipulation of the people. But sir, the alleged BAC in this matter is a 0.21 and there was a crash. So it's unlikely that I will be changing that.
I'll also note for the record, Your Honor, there was a 6-year-old in the car.
Yes. All right.
I'll speak to my client further about it, Your Honor. Thank you.
Thank you.
Thank you.
Court does call the case, People versus Marcus Moore Jones.
Actually, one of the people.
Excuse me, Your Honor.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Moore Jones, who is present today via Zoom. Sir, can you please state your name for the court?
Marcus Moore Jones.
All right.
Thank you, Your Honor. There was an offer made in this case for my client to admit to the civil infraction of no proof of insurance, and in exchange, the misdemeanor charge would be dismissed. I did discuss that with my client, and that is what he would like to do today.
And that is a correct and complete recitation of the agreement. Does the court need that reduced to writing or?
No, it's a civil.
Thank you, Your Honor.
All right. Is that 155? 155.
Yeah, 257, 328 is that pack code, Your Honor. Thank you.
All right. And Mr. Moore Jones, do you admit responsibility to the fact that on April 29, 2025, at US 23 in Pittsfield Township, Washington County, State of Michigan, that upon lawful request of an officer, you are unable to produce proof of insurance?
Yes, Your Honor.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $155. When can you get that paid?
Can I do the beginning of next month?
Beginning of August?
Yes, Your Honor.
If I make it August 1st, will you be able to pay it?
Yes.
August 4th. I don't believe it, but you have it on the 1st. All right.
Thank you, Your Honor.
All right. You take care.
Thank you, Your Honor. Thank you, Marcus. You're all set for today.
Okay.
Court calls the case, People versus Ashley Garcia.
Actually, people. This is a short call.
On a failure to, she's here. Hello.
I'm here.
What's
Ashley
your,
Garcia.
all right. Ma'am,
There's my name.
you are before the court on a misdemeanor complaint or citation that alleges that on or about April 23rd, 2025, at the location of South State Road in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle without proper security.
Yes, I didn't.
That is,
Sure.
hold on. You understand the nature of that charge?
I do.
All right. That's a misdemeanor punishable by a fine for up to 1 year incarceration. Fine not less than 200 nor more than $500 plus court costs. You understand that?
I do.
First question I have for you is, you want to be represented by an attorney?
I don't think so.
Pardon?
I don't think so.
Do you know what you're going to do?
Pay the ticket? I don't know. No, I don't know.
Really?
I don't know.
You don't know? Do you think an attorney could help you with that?
I mean, sure.
You
Yes,
think? You
yes.
think an attorney could?
They could help, yeah.
They can help?
Yes.
So I'll ask the question again. Do you want to be represented by an attorney? Yes, great. Okay. PD case.
Sorry.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Garcia, we would waive any further reading. My client stands mute, and we would ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a pretrial in this matter. Might be able to resolve quickly. So July 16th, 2025,
Thank you, Your Honor.
9 a.m.
Can I say something? I
Pardon?
do have 2 doctor's appointments that day.
Pardon?
I have 2 doctor's appointments that day.
Oh, okay. Will August 6th work better?
Yeah.
Okay, August 6th.
I just didn't wanna.
No, it's okay.
Not show
As
up
a
again.
25.
So,
Thank you,
Yeah.
Your Honor.
yes,
That's right, because you've already done that one.
yes.
So, all right. That's at 9 a.m. I'll set her bond at $5,000 personal recognizance bond, standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug.
Yep.
All right, that's all we'll do. All right, thank you.
Thank you, Your Honor.
Thank you.
Court calls the cases of the people versus David Martin. Gotcha. David Martin. No response. Rather than issue an order should cause, I'm gonna go straight to bench warrant. There's another warrant pending. Mr. Martin, bench warrant will issue. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case people versus, is it Trendis Martin?
Special money for the people.
Trendis Martin? No reflect, we've had a bench conference.
Your Honor, we're going to need at least a week adjournment because discovery is incomplete.
All right. Is there somebody here with you or did they send you on your own?
No.
No,
Do what?
they sent you on your own?
Yep, Amanda took the day off.
Okay, there's supposed to be a green form filled out.
I'll fill it out.
Could somebody help Mr. Benson? Thank you. All right, probable cause conference in this matter will be adjourned to July 17th, 2025, at 9 a.m. Bond on this case will continue. Mr. Gonzalez, I was informed, and I think you have been informed that there's a violation of probation warrant. And that has no bond. So on it, Mr. Benson, did you want to, you don't represent him on that?
No, I don't, but I've talked. And Your Honor, on this present case, could he have at least $100 cash bond so he earns some time?
Objection to the cash bond, Your Honor.
I'll set his bond in this, on the case that I just called as a 1,010% bond. All right,
That'll be for time.
but on the warrant was issued by Judge Slay. There is no bond, it's violation of probation warrant. I'm going to remand you to the Washington County Jail.
Try to get you a range.
The time that you can be heard in that
We
court.
gotta go with this.
All right, he's remanded. Court does call the case of, are they there? Court calls the case of the people versus Robert Middleton. Morning.
Like the Fatima hearing, yes, and on behalf of Robert Middleton.
Your name, sir?
Robert Middleton.
All right. What are we doing?
We would like to set this matter for a preliminary exemption.
All right. All discovery is complete.
Yes, to our knowledge.
People have their witnesses available on the 15th. All right. Preliminary examination will be set in person July 15th, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you, Your Honor.
Court calls case of the people versus Virgil Dunlap.
Andrew Children, Tech Council. That's Mr. Cruz.
Virgil Dunlap. We have Miss Yagi listed, so.
Can't look it up. Is it okay, Sharon?
Pardon?
We can flip it off.
Okay.
I believe we're looking for Mr. Drucas right now, Your Honor.
That's it. Court calls case of people versus Ibrahima, is it Daikite?
Good morning, Honor. And Assistant Public Defender, Tanavi Teriyaki, on behalf of Mr. Ibrahim Diakite.
Mr. Diakite, state your name for the record when you reach here, please.
Judge, good morning. I was appointed on his home invasion third matter on 23 F 10699.
10699.
Yeah, last night about 7 o'clock.
Students informed me that, I usually have an interpreter. Is that accurate or-
You understand? No, you understand English, correct? Is that a yes? Is that a yes?
Yes.
Okay,
So he does not need an interpreter?
I don't believe.
Do you need an interpreter?
No.
No, Your
All
Honor.
right. What are we doing on these?
Your Honor, we're asking for an adjournment.
Yes, Your Honor.
Three matters.
Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond in these matters will continue.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
Court does call the case of the people versus Tanya Hall.
Morning, Your Honor. Just go on back to Ms. Hall. Judge, Ms. Hall here. Judge, as you know, Ms. Hall is an elderly lady. She lives at the Delana Center. I have no phone. I have no email. I would ask the court, you being the compassionate judge you are, if you would adjourn this 1 week. I will go.
We received a communication from Community Corrections indicating that your client presumably left a voicemail, or a woman, that Ms. Hall was in the hospital. She then received an email stating that she was discharged from the hospital. So I don't know why she's not here.
Judge, you know, I believe you know her circumstances. Would you give me 1 week? I will go to Delana Center and inform her. I have no other means of communication.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000. Cash surety. I won't have the warrant issue until the 8th. Give you time to try to find her.
Thank you, Judge. Appreciate it. Have a good fourth.
I will be. Court does call the case of the people versus Anthony Turner.
Your Honor, the person they had waiting is not Mr. Turner. I do believe they're going to go back and get Mr. Turner. I don't know who the individual was standing there, but Stephanie can on behalf of Mr. Turner. Okay. Oh, where are you? Your Honor, we are asking for an adjournment. He has been screened for mental health court. We're just waiting for the evaluation. Hopefully with that, the prosecutor and I can come to a resolution. We are waiting for it. They have to give it to us.
Will the 17th be enough time? You need 1 more week.
Your Honor, they indicated that they were going to try to get it to me today. When I checked, it was not there. So that should be fine.
Give you 2 alternatives. That should be fine.
Whichever
July
one-
17th, July 17th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Court calls the case of the people versus Mary Collins. Practice is granted.
Kyle Burrell on behalf of Mary Collins. Ms. Collins, please say your name.
I'm Mary Collins.
Just so you understand, date and time set for probable cause conference. I have been speaking with EPA Ward on this this morning about trying to come to some sort of resolution. We're asking for a 1 month adjournment here to let Ms. Collins.
1 month. Why do you need 1 month?
Which is basically to Ms. Collins basically needs to earn an offer at this point. And so we're giving her some time to provide that material and provide that proof. We can do less if the court.
Well, you're going to do whatever I say, but I'm just trying to figure out why you may need it.
Your Honor, I talked to Mr. Bordello about providing mitigation information. I was thinking that could happen in circuit court or down here, but we have to keep things moving, so I have to turn the court.
And if the court would like to see it sooner, we can do that as well.
July 24, 2025, 9 a.m. Bond continued.
Thank you, Judge. Welcome to the hallway.
Thank you.
Thank you, Judge.
Court calls case of the people versus Sean Newcomb.
Okay, Richmond, looking for the people?
Appearing with and on behalf of Sean Newcomb. Please state your name for the record.
Sean Newcomb.
Has the court received the evaluations from the forensic?
I have.
We have nothing further to present in this matter. An order finding him competent.
Based upon a review of that report and the evidence submitted, the court would find that the defendant is at this time competent to stand trial. We specifically find that the defendant can understand the nature and objects of the proceedings against him and rationally assist in his defense. Therefore, the defendant is deemed competent. Do I have an order?
Yes, we've sent an order finding him competent
When did you send the order?
earlier today
Oh, this morning in the middle of this docket.
before the
So right now, we really don't have an order.
before the
But
doc.
I have to have my staff pull it off
Yes, Your Honor.
and stop everything to have it happen. Do you?
Oh, there you go.
What do you mean, there you go? You sent it this morning. Really? 9:12, even after the docket time start. Did Brown tell you to do that? He did, didn't he?
No, Your Honor, I didn't.
You don't have to fall on the sword for him. All right, I signed the order that came in late.
Thank
All
you,
right.
Your Honor. We would like to set this matter for PCC.
Set a probable cause conference with 2 weeks be enough time for it. Set a probable cause conference July 17th, 2024, 9 a.m. Bond will continue. Court calls case of the people versus Jessica Hafner.
Morning, Judge Calbell, on behalf of Ms. Hafner. Approaching the podium. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you. And Your Honor, I was just very recently appointed on this matter. We are asking for a brief adjournment at this time.
July 17th, 2025, 9 a.m. Bond continue.
Thank you, Judge. If the defense may be heard as to bond.
She's out. 17th.
Thank you, Judge. So Ms. Hafner currently has a no contact order with her children. 2 of her children have a bad hereditary condition that requires constant and fairly advanced medical treatment. There could be a hospitalization or I believe you said a surgery sort of at any given time. Name of the disease was too complicated and long for me to even write down here, but we are asking for a modification to the no contact order to allow supervised contact for the purposes of medical treatment only.
Response from the people.
We would ask that the bond remain set where it is until we can get an exam or resolve the case.
I mean, is CPS involved?
Your Honor.
Has CPS?
I'm looking, a referral was complete at the time of this investigation.
Right.
They're pacing it.
How many children are involved in this one?
Elijah appears to be the victim.
There's only one child named in the complaint, Judge, yes.
As far as I don't know, the victim. I mean, I was concerned, Your Honor, when the police came to investigate, the defendant took a long time to answer the door. She said that he was sleeping and they needed to check the welfare of Elijah. He was in his bed covered with a blanket but not sleeping. They immediately observed blood coming from his face as well as tears from his eyes and blood touching. So we would ask that bond continue. I don't think it's appropriate for the contact with the patient.
And for what it's worth, Your Honor, Elijah is not one of the children that has the condition.
Well, but I'm not, you know what, I'll tell you, I'm not going to change this, and I'm not going to change this on the fly, certainly. I believe that it should be changed. File a written motion, I'll hear it, but I'm not going to do that. Motion for bond reduction is denied at this time, or bond modification is denied.
Understood. Thank you, Judge.
Court calls case of the people versus Thomas Bash.
Morning again, Your Honor. Constable Bill Basie on behalf of Mr. Thomas Basher, who's approaching the podium to my right. Mr. Basher, can you state your full name for the record, please?
Thomas Basher. All right, what are we doing?
Are you sure? Yeah.
Really?
Sorry. Your Honor, today's the date and time set for probable cause conference. At this time, my client has been offered by the APA, and he wishes to avail himself of that offer, Your Honor.
Your Honor, plea offer extended by the people was that Mr. Basher was being charged count 2, being dismissed count 1.
That's correct reflection, Your Honor.
You fill out a plea form? Even though it's a stated count, I've got to have the plea form.
Okay, I was under the impression that the plea form didn't need to be filled because it was already on there, but
I know that. Although it's a stated count, because of the changes, but the defendant has to acknowledge you need to fill out a plea form. I don't care whether it's stated.
Understood.
I'll pass it. Thank you. Court calls case people versus Bianca Rao.
People.
Hey, you went out.
Good morning. What's your name?
Bianca Rao.
Where's Mr. Pradell?
You know,
Seriously.
On behalf of Ms. Rowland, my apologies, Judge. Ms. Rowland, have you stated your name? Okay. So, Your Honor, today is the date and time set for probable cause conference. I have given quite a bit of mitigation documents to the prosecutor. It's my understanding they need a little more time to review that. And so we are asking for a brief adjournment.
July 17th, 2025, 9 a.m.
Thank you, Judge. Talk out the hallway, maybe.
Case of the cases of the people versus Todd Rager.
Fernandez for the people.
Assistant Public Defender Jay Bellinger on all cases not ending in 0891, Your Honor.
Kyle Bredelin, the only case ending in 0891. And you'd have to go for this one, phone number. Thank you, sir. It's submitted. Thank you, sir. Apparently, I didn't even know that.
Can you state your name for the record, sir?
Todd Rayburn. All right, what are we doing?
Your Honor, yesterday I submitted an order for the court, a stipulated order for the court. My understanding is that all other orders are signed for him to, in an effort for him to go to treatment. My belief is that these are the only two cases that I submitted to the court, the stipulated order for, that he does not have an order signed in order for him to go to treatment. We were asking. I'm sorry?
I signed the order.
Okay, we were just asking for a 3-week adjournment in an effort to get him into treatment and track his progress.
Mr. Burdell.
Judge, defense moves into would join that motion on my case as well.
Probable cause conference, July 24, 2025, 9 a.m. bond will continue.
Thank you, Your Honor.
Yeah. Court does call the case of the people versus Taylor Adams.
We're ready on this matter, Your Honor. I'm Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Taylor Adams. Mr. Adams, could you please state your name for the record?
Taylor Adams. Thank you.
Your Honor, today is the date and time set for a probable cause conference. We have made great strides in working out a plea agreement. However, there's still some further information that we'd like to provide to the prosecution. So we'd ask for a 1 or 2 week adjournment so that that can take place.
Probable cause conference without objection, July 17, 2025, 9 a.m. bond will continue.
Thank you very much.
Thank you, sir. Thank you. Court calls case of the people versus Brooke Bailey.
Assistant Public Defender Jay Bellinger on behalf of Ms. Bailey. Ms. Bailey, can you please state your name for the record?
Brooke Bailey.
Your Honor.
She's waiving.
Yes, she is.
Ma'am, you're waiving your right to a preliminary examination?
Say yes.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right. Preliminary examination having been waived, defendant found over to circuit court on a single count.
Acknowledge receipt of information, wait formal reading, stand mute at this time, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
At 1:30.
July 22nd, 2025, 1:30 for Judge Comfy. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case people versus Abdul Rahman Abdallah. I messed it up again. But we'll get it.
And Alex Warren Green on behalf of Mr. Al-Dayef. Could you please state your name for the record?
Exactly what I said.
Your Honor, today's date and time for probable cause conference. At this time, we are requesting an adjournment to complete media discovery.
To do what?
To complete media discovery, Your Honor.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call case of the people versus Quincy Jones.
If you
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Jones on case ending 0697.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Jones in case 21574.
Okay, in both cases, I have indication that there are plea agreement form that he is going to be guilty to an added count 2 of use of a controlled substance in both matters, a 1-year offense upon a successful plea with those charges count 1 in each.
That is correct, Your Honor.
That is correct, Your Honor. I have gone over his rights with him.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me God, yeah.
State your name.
Quincy Jones.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 counts of use of a controlled substance. All right, is that correct?
Yes, Your Honor.
Those are misdemeanors punishable by up to 1 year incarceration at $2,000 fine plus court costs. You understand that?
I understand.
You understand also in one of the cases, while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
That's right.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance contained in case ending in 0697, how do you plead?
Guilty.
To that same charge contained in case ending in 0574, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights?
No, I read them thoroughly.
Pardon?
I read them thoroughly.
You understand them?
Yes, I do.
All right, so you have no questions.
No question.
Is anybody? I think we look at paragraph 5, copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
He's asking if everyone's made you any promises. We have.
No,
Anybody threaten you or coerce you in any way?
no, I haven't.
You're doing this voluntarily
Yes, I am.
of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of these offenses?
Yes, I am guilty of these offenses.
Okay. Starting with the case in the 1482 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I have.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes,
Had you used it?
yes,
Did you know what you were using was fentanyl?
yes, I did.
All right. Sir, I need you to also understand that if I accept your plea and between the time of sentencing and the time of, between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation would, the court is not bound by that. You understand that?
That's it.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule and would it be proper to accept the defendant's?
People satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count 1 is dismissed. In the 1482 matter, pre-sentence investigation and report is ordered at 1482 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address?
I knew it. I was trying to sneak it in before you said something, rushing. In the other matter, let me just finish up the other matter. In the other case, defendant is count, if I didn't say so. No, count 1 is dismissed, except the plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1481 probation. Sentencing will be. No. I have a sentencing. He's in custody. That's the date will be July 9th, 2025. Time 9 a.m. So you can come here and then get over to Judge Barr, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor.
And
But Your Honor.
It wasn't just he didn't go to community corrections. Isn't that correct?
That was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Jay probably came down off all those drugs. Go ahead.
Well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at a sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor, consider reducing this down to a personal bond.
Your Honor, I would just add that I have been in touch with the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and have to fill in this person as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else we have in the system. The concern will add to that is that prior to that, there's a court under the influence. Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of saying drugs
And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I would prefer that he at least remain in custody until his sentencing on July 9th.
All right, until I have an additional evaluation, I'm going to deny his request for any type of bond reduction. Defendant bond will continue in each book.
Thank you. Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Court calls the case, People versus Elton Bell. Oh, boy.
Good morning, Judge. Ken Madadish on behalf of Mr. Bell, not with. Mr. Bell is 65 and is not able to drive. He had a ride who was supposed to bring him here. He told me he's
If
fine.
you say he's coming on a bus, I'm coming up.
He's not, I don't even think he can navigate a bus. Not because of, he just, I even tried to get him on Zoom. I don't think he can navigate that either. I would have gone down that route knowing he does not have a ride, a consistent ride. In any case, Your Honor, can we please pass on this?
You want me to pass it?
Yes, please. I'm
Okay.
trying to find
Then what's
another.
going to happen?
When he comes,
Between,
oh, he's finding another ride. He's appeared every time before, Your Honor. I believe it's his first time not appearing. I can get him to send photos of a bus.
of what? You know what?
If that would
You know
be
what?
help.
I do. I'll pass it.
Thank you, Your Honor. Thank you, Your Honor.
Wow. Court calls the case, People versus Rahman Muhammad.
Andrew Childers, on behalf of the people.
Kyle Bedell on behalf of Mr. Mohammed. Mr. Mohammed, please state your name.
Rahman Mohammed.
And Your Honor, may we approach briefly? Very briefly.
Yes.
Thank you, Judge.
All right, record shooter, we had a bench conference in this case. They're requesting an adjournment.
Yes, Judge.
Probable cause conference, July 17, 2025, 9 a.m. Bond continues.
I will be in touch for a while.
Court calls case, People versus April Black.
Your Honor, Alexis Plumey on behalf of Ms. Black. And Ms. Black, could you just state your full name? April Black. And Your Honor, today is the date and time for a probable cause conference. I do have a green sheet filled out. We are just asking for an adjournment for plea negotiations. If we could go about 2 weeks. And then, Your Honor, I would like to address a couple conditions of bond.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Yes, Mr. Bond.
So currently, Ms. Black is on a GPS tracking tether. And there is also an order that she not go to her mother's house, but not in order that she not speak to her mother. Ms. Black lives about a block away from her mom. It's my understanding there was an incident immediately preceding this one that is still being investigated, where Ms. Black and her mother would be the alleged victims. From what I understand, Ms. Black was ordered not to go back to her mother's place because another person involved may live in the area. However, Ms. Black has 4 children, she's still living a block away from her mother's house, and it is just inconvenient that she can't go over there and drop her kids off because her mom does help with childcare. And additionally, I feel that condition doesn't really relate to the charges in this case. So if you'd consider lifting that no-go to and removing her GPS tracking tether. And I don't believe there's any suggestion that Ms. Black is a flight risk.
Response.
I would ask at least for this, at this point, the remain is currently set. When the police had contact with Ms. Black, it wasn't a call regarding potential FA, but she was highly intoxicated, really aggressive with police, ended up doing police car was combative. I'm just concerned, whatever the heck is going on at that 407 address. I would hate for there to be any sort of bringing up whatever dispute led to the initial contact that would cause Ms. Black to have a negative impact on this case.
Motion for modification of bond, changing any conditions is denied. Bond will continue with its conditions.
Your Honor, if I could just clarify about the tether, I believe the tether is just tracking her. It's not an exclusion zone.
It's a location tracking tether.
Yes, so I'm not sure what purpose that,
So you
It's-
want me to redo the ruling I just gave? Is that what you're asking? How many times have you been before me? Yeah,
Few.
how many times have I ever done that when I finally ruled?
understood, Your Honor.
Never.
Understood.
So I don't know why you think I'd start today. So are we done?
Yep, we're done.
Okay, thank
you.
Court calls the case, People versus Raymond Bowman.
Crossing the base on behalf of Mr. Bowman, Your Honor. Mr. Bowman, can you state your full name for the record?
My name is Raymond William Bowman.
I have before me a plea form. Is that what we're doing?
Yes, that's correct, Your Honor.
Plea form indicates that the defendant will plead count 2, possession of a weapon in a weapon-free school zone. Misdemeanor. And upon a successful plea to that charge, count 1 would be dismissed.
That's correct, Your Honor.
Is that a correct statement?
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Raymond William Bowman.
Sir, it is this court's understanding that you are pleading no contest to the charge of possession of a weapon in a free school zone, in a weapon-free school zone. Is that correct?
Yes, Your Honor.
You understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea, I have to make sure that you understand. The first thing about a no contest plea that you have to understand is that it means that you are not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
Your Honor, potential civil liability.
And understanding all of that, sir, you still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights of that form.
I understand, Your
You
Honor.
understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am on probation in Wayne County.
Were you on probation at the time of this offense?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 4613-20. Any objection to the court having reviewed that report?
No, Your Honor.
No objections, Your Honor.
Counsel, there's not an indication of a school, the zone.
It would just be to the higher, Your Honor.
So accepting the higher,
There's no good misdemeanor for firearm.
so in looking at that, then, sir, if I do accept your plea, I have to have you understand that any sentence evaluation, if there were any or any recommendation, the court would not be bound by if you committed any misconduct as defined in the Michigan court rules. You understand that?
Yes, Your Honor.
You also understand that you not be entitled to withdraw your plea.
Yes, I understand.
Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
And have I complied with the court rule and would it be proper to accept this offense?
Yes, Your Honor.
The defense is satisfied, Your Honor.
And based upon the police report, the court would find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. The court will accept the defendant's plea to no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14:1 probation. Sentencing in this matter will be July 9, 2025, 9 a.m. That's before me.
Your Honor, may I respond when appropriate?
You may.
Your Honor, my client is asking to be released on a PI while he waits his sentencing. My client is unfortunately very ill. He needs to go back to the hospital. He's actually due to have a procedure done today at 3 p.m. It's quite an intense procedure. He's also going to be
Is this the only thing holding him?
here. Yes.
What do you mean here? Yes.
He has a hold out of waiting for the BMI. He has been warned 4 times in this case already. So people think that he should be held until I receive that permission.
The bench warrant, I believe, was due to him being hospitalized, and that's why he failed to appear previously.
What about the bench warrants in?
I'm to be released to treatment from Wayne County. That's why my sentencing I'm going to the Salvation Army, and I need it set up on Zoom. So if you were to release me, I would go to Wayne County Jail and wait for treatment to pick me up. And then I would be at the Salvation Army there.
Anything else?
Nothing further, Your Honor.
I don't think it's appropriate, given the defendant's track record in this case and the very fact that he has another hold to release the defendant. Therefore, the motion for bond reduction in this case at this time is denied. I'll be seeing him next week. So,
Understood, Your Honor.
thank you.
Thank you, Your Honor.
Court calls case of the People versus George Bowman.
Zachary, what on behalf of the people?
That's the public comment on behalf of Mr. Bolton, who is now approaching. Can you please say your name for the record?
George Bowman.
Go ahead.
At this time, Your Honor, be saying this matter for preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 15th. What is that? Yeah, I do feel threatened, but Alan doesn't. What is that? We don't know. Have we ever figured out what it is? Just that happened to me? No, I'll be good. Don't worry about it. No, I'm all right, man. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Washington.
He'll be here. Yeah.
Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Troy Brumfield.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Brumfield. And Mr. Brumfield, could you state your full name?
Troy Brumfield.
And Your Honor, I do have a green sheet here. I am asking for an adjournment. I was not aware that Mr. Brumfield was in custody until this morning, so I would need some time to go over discovery with him. And I would again like to address.
And you're also, you want to address this bond?
I
Have
would,
you seen the new complaint for a conditional bond violation?
I have.
Okay, go ahead.
Your Honor, Mr. Brumfield was just arraigned last week. I do understand that there were 2 violation reports filed, one for a failure to test on the SoberLink device that was ordered, and the other for a new complaint with the allegation that Mr. Brumfield allegedly took some food from the University of Michigan Hospital. I would still ask Your Honor to consider a personal recognizance bond here with a scram tether rather than a SoberLink. I think that might be easier for Mr. Brumfield to test. And it's my understanding that he.
Are there new charges that are going to be coming from that?
Your Honor, as just you, we have not received a new warrant request yet.
Got it.
Receiving it shortly.
Yes, and yeah, it's my understanding that he's not being held on anything to do with the new report.
Any response from the people?
Your Honor, we would reject the defendant's release at this time, considering the 2 separate bond violations. History that does include the brought in his prior DUIs. If you were considering his release, we would ask for that script. Heather, considering that he did not test at all on his sober.
That's part of the problem. He didn't test. And that is allegedly out there, at least, or places himself in a position where he's committed another offense.
I understand, Your Honor, and I think the scram tether would solve that testing issue. And I would just emphasize that it was just a few days that he was not testing. I did attempt to reach out to him when I found out, but I believe we just didn't have updated contact information for him. Would still ask the court to consider a personal bond and a scram.
Motion for bond reductions denied. Probable cause conference is adjourned to July 17th, 2025, 9 a.m. Bond will continue as denied at this point. She's sloughing off. Court does call the case of the people of the state of Michigan versus Grace Brenner.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Brenner. Your Honor, can we approach?
I didn't know. You just started walking up. I told you I feel unsafe. No, she didn't let me. I had to throw it back. Oh. All right. Record should reflect your kind of bench conference in this case. Defendant is not present. Court will issue a bench warrant for defendant's failure to appear. Bond is setting him at $10,000 cash surety. That warrant will issue immediately.
Yes, sir.
Court calls the case People versus Robin Finney.
Your Honor, Alexis Blumey on behalf of Ms. Finney, who is approaching. Ms. Finney, could you just say your full name?
Yes, Robin Lee Finney.
Thank you. And Your Honor, we are just asking for a brief adjournment for plea negotiation purposes. And I am not asking to address bond.
Shocking. Probable cause conference will be adjourned to July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Court calls the case People versus James Lee Harbin.
Cameron Daddish on behalf of Mr. Harbin, who is appearing by Zoom. Mr. Harbin, can you please state your name for the record?
James Lee Harbin, Harb as in boy I am.
Your Honor, we are requesting an adjournment so we can continue plea negotiations with the prosecution, please. Already did it.
Where is he held? Sitting.
No. He's at
That's the reason for the Zoom.
Valley. I forget the Villa, sorry. Let me get the exact name. Villa at Park Ridge.
Got it.
The rehab center.
July 24th, 2025, 9 a.m. Bond.
Thank you.
Court calls case the People versus Frank Clark.
Cameron Daddish on behalf of Mr. Clark, who should also be appearing by Zoom. Mr. Clark, can you state your name for the record?
Frank Clark.
Your Honor, we are requesting a 1-week adjournment. We have a resolution on this case. We just need 1 more week to finalize that.
I'm not going to do it that way. Probable cause conference, he's out of custody, will be July 17th, 2025, 9 a.m. Bond continues.
Your Honor.
Court calls case of the People versus Kyle Humphreys.
And Assistant Public Defender Nicholas Bukovich appearing on behalf of Ms. Humphreys in both matters. There should be 2 cases, Your Honor.
Yes. All right, what are we doing?
Your Honor, I'll be requesting a brief adjournment to obtain outstanding video discovery in the case that ends in 0889, and I would be requesting to address bond briefly.
Did Plumai put you up to this?
No, Your Honor.
No, go ahead. I will adjourn these out to the 17th, 2025, 9 a.m. Go ahead.
Yes, Your Honor. In the case that ends in 0889, Mr. Humphreys currently has a PR bond. From my conversation with my client, I do believe he'll be held based upon his bond in his other case. So I'll just be requesting a nominal cash bond to allow him to obtain time for
Which
credit.
case is he on?
In the case 0907, he has indicated to me that he cannot currently post that bond. In case 0889, he currently has he was granted a personal reconnaissance bond, so I'll just be asking for a nominal cash bond to allow him to get credit for time served in both matters. I would also be asking for a release to treatment in both cases, and I understand the court would like an order filed with that.
Just filed an order to say about release anybody to treatment if that's what they want. I'm not going to have a problem with that unless there's some objection. Just get a stipulation to do that.
Yep, and I will get that to the court as soon as possible, Your Honor.
All right, so I will adjourn the matter to the. I'll adjourn this matter to July 17th, 2025, 9 a.m. With reference to his bond in case 09 or 0889, I will reset his bond to a $1,000, 10% off. All right, so that he receives credit. You'll have to. Thank you. Court does call the case People versus John Cotton.
If you're Richard McDuffie for the people.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Cotton, who should be appearing via Zoom.
Mr. Cotton, please state your name.
John Cotton.
Your Honor, at this time, we'll be requesting an adjournment to for the client to pay some restitutions toward his offer.
PCC will be adjourned July 17th, 2025, 9 a.m. Bond continued. Court does call the case of People versus Chad Brown.
Please state your name for the record.
Chad Jones.
Your Honor, we are requesting a brief 1-week adjournment for a global resolution. The prosecutor needs 1 more week to get in contact with 1 witness. So we have 2 on board. They just need 1 more.
Some green sheet.
Yeah.
You're gonna be able to get it all accomplished in 1 week, so I'm not gonna be back here and then ask you for another week.
Yes, Your Honor, everything is set except for 1 thing, and once that's addressed, it's be set.
Probable cause conference will be adjourned to July 10th, 2025 on all 4 cases, 3 cases. 9 a.m. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Donovan Dronkowski.
Councilman Basie on behalf of Mr. Gronkowski, but not with him, Your Honor. Unfortunately, I've not had contact with my client. I'm unsure of his whereabouts at this time.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. That warrant will issue immediately.
Your Honor.
Court does call the case People versus Daniel Franklin.
Andrew, this on behalf of people, Your Honor.
Good morning, man. Please, Honorable Court, Kareem Johnson, on behalf of Mr. Franklin.
Pardon? Your name, sir?
Daniel Franklin.
Thank you. All right, what are we doing on this case?
I spoke with Mr. Johnson. I don't know what, I believe he has been tendered discovery, and I think we're just looking to set this matter for an examination.
Is that a correct statement, Mr. Johnson? You'd like this matter set for prelim?
Yes, Your Honor, and we're asking that the prelim be set out a ways. I believe the people will be calling a cooperating witness who is in federal custody because of the likelihood that this witness may become unavailable down the road. I will be asking for the people to present any and all information they have relevant to cross-examination under US v. Giglio. And I think the people may need some time to get that. And I don't know if the people are even in possession of the federal indictment in which this witness is cooperating under and giving this testimony, but I would like to have that before exam as well.
I have no problem with that. I have no problem with setting this matter out. As the court may remember, Mr. Franklin is being held on another homicide case that is pending before Judge Conlon with a trial date well into the reason.
So why am I setting it for exam if everything's not ready?
This cooperating witness is currently being held at FCI Milan. The moment we have an examination date, I give a writ to them.
Yeah.
They won't transport him. Otherwise, it sounds like he's going to eventually go to West Virginia, and I'd like to have that writ before the Bureau of Prisons transports him out of the state. So the date,
especially to West Virginia, because people don't come back. No, I'm kidding. I love West Virginia.
I don't think so. And so that would be the reason I know. And as I spoke, Mr. Johnson and I spoke yesterday, and I believe we're on the same page.
All right. So to get accomplished everything, how much time are you guys looking at? I get why you want a date out. I'll set the exam, but
perhaps I don't know what the court's availability is. I'm looking into kind of
mid-August. I can do August 12th. I can give you a prelim date on August 12th.
That works for the people. That works for Mr. Johnson.
Your Honor, on August 12th, I have another homicide exam in the Lansing District Court.
Gotcha. Well, that's my only set PE date in that date. Did you want me to kind of give you a Monday and that way more flexibility to do that?
August 11th, if the court is available that day, that would be perfect for me, Your Honor.
Monday would be fine, and just for the court scheduling purposes, I wouldn't expect this to be something that would take more than half a day.
Okay. That's okay. So what I'll do is I'll just put it on my docket. I should have asked, do I have the 11th available? And if we don't pick a jury selection in the morning, so I can set it in the afternoon. Oh, I did set a note in here. Okay. Pardon? I can do Monday, the 18th. Will that work for you, Mr. Johnson?
I'll be at a jury trial in the Washtenaw County Circuit Court on the 18th, Your Honor.
They'll wait. No, I'm kidding.
The 25th works for me if that works for the court.
No, because I'm gone. Right. Well, August, I know it's going the other direction, but would August 4th work?
I think August, at least from the people's perspective of getting the information, Mr. Johnson, August 4th would work for us.
Mr. Johnson, August 4th work?
I will be in trial August 4th, Your Honor.
The whole day?
Yes, Your Honor.
Just, all right, give him a Tuesday. I don't know what Johnson's schedule is. I don't know why I'm setting around Johnson anyway.
My other thought is if we could set it on a Tuesday, perhaps that's well, knowing that we would then get closer to the date and perhaps talk with the court about a skip to move it. As long as I have the date to hold this witness, I don't care if we move it. I can send.
Why don't I do this then? And then this way you can kind of figure it out and then we can move it up to give you more flexibility in terms of dates, because then we'll be able to figure out my dates a little bit. I'm gonna set it on July 22nd. Okay, with the understanding that you guys may have to move it, but then we'll move it on my docket now, okay?
Yes, Your Honor.
So preliminary examination in person will be set July 22nd, 2025. That's at 12 noon. So that's an afternoon prelim docket or PE docket for me. All right?
Thank
Thank you, Your
All
Honor.
right, Johnson, I'll contact you early next week. And go over
Yes, sir.
everything, okay?
All right, thank you, Mr. Johnson. Court calls case of the People versus Dave Ellington.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Ellington, who's pushing out. Your Honor, Mr. Ellington will be waiving his right to a preliminary exam. I'd ask if the people would place the offer that was extended on their record.
Your Honor, Mr. Ellington is part of the financial transaction advice. The offer is.
The offer is 2 and a 10. Is that your understanding?
Yes, Judge, thank you.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right? People also waive their right?
Yes,
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we would acknowledge receipt of the information, waive formal reading. The client would stay mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set.
August 8th, 2025 at 1:30 with Judge Simpsons.
August 8th, 2025, 1:30, Judge.
No, you're good. This is just your notice.
Oh. On continue.
Thank you, Judge.
Thank you.
I'll finish this.
Court calls case of the People versus Jaleesa McDowell.
Your Honor, Amy Riser, here on behalf of- Your Honor, Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Ms. McDowell.
Okay, permission to practice is granted.
Thank you, Your Honor. Ms. Dr. Producer, any further court calls?
Jaleesa McDowell.
Thank you. All right.
Your Honor, we would like to request the court set a date for exam in this matter, please.
All discoveries complete.
Yes, Your Honor.
People have their witnesses available the 15th?
Yes, July 15th.
Yeah, July 15th. Will that work?
Yes. And Judge, I said we should.
Preliminary examination in person will be set July 15th, 2025. 9 a.m. That is before Judge Moore. Esteban.
Thank you. Counsel has been provided with several of the defendant's jail calls. And we're asking that her calls be revoked at this time. She's actively trying to have third parties contact the minor child in this case to have her recant. So we're asking that her jail calls be revoked and if necessary, a date be set for here.
Your Honor, I've listened to the calls myself, and while in some regards, Ms. McDowell does talk about her case to people, she very rarely makes requests. Her tone is not demanding or threatening or coercive.
Rarely makes requests?
Well, I mean, I'm talking about a request in general, Your Honor. So, but there are a lot of conversations, and for the most part, she her tone is not demanding or threatening or coercive in any way. And mostly she's just talking and trying to communicate with her mother, her grandmother, and her cousin and other family members.
But are there indications that not only, because those would be third-party contacts, but is there an indication where in any reasonable fashion it could be read she's making a request for somebody to recant their story?
Your Honor, I believe that in most of the situations and most of the phone calls that we heard, she wasn't making requests as much as just expressing how she was feeling about certain issues with her grandmother and her mother and the people who are taking care of her children right now.
It really doesn't answer my question, but
Yeah,
that's
right.
fine.
We did meet with Ms. McDowell yesterday and we talked about that. I will say Ms. McDowell was very candid. We went through some of the phone calls together. Her understanding, she had no intent to disobey the court's order. She's not in any way trying to intimidate or coerce anyone to come to court or to not come to court. Her position is that she has other children involved. She was getting messages that these children are left unattended at her home. She's very concerned about the safety for them. That has now been resolved. After my conversation with McDowell, she even said, I don't plan to be on the phone anymore. I was never trying to disobey the court's order. That was not my intent, but obviously she has concerns for the safety and well-being of other children that are currently, they now are placed with someone that she knows, and she does not have that same concern for their safety. Son.
If I could, I'm provided to offer a proof, just an excerpt from one of the calls.
Yes.
This is the defendant speaking on June 19th, 2025. She's got mental problems. She's got mental problems. Me and Melody don't speak because she done it for $300 worth of damage in her house. I think you all will speak up for me and share her stuff too. Like, that's not fair. That's at 2:11 in the call. And at 5:08 in the call, the defendant says, I probably could get her a ride to court like that. I know I can get unintelligible. Who she's speaking with, I believe it's the grandmother. Let me give her a ride. Let me get her a ride. I'll take Talisa out there. Let me give her a ride out there. The defendant. What are you talking about? Is she really coming to the court? And the grandma said, we haven't talked about that. We haven't talked about that. And the defendant responded, no, you got to talk to her about that, Mom. And I could go on.
Seems enough for me. Motion to revoke defendant's phone privileges is hereby granted. Defendant's phone privileges are hereby revoked. You can always ask for a hearing on that. All right, thank you. Court calls the case People versus Darius Grady.
Good morning, Your Honor. Amy Reiser, appearing on behalf of the people.
Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of First Assistant Public Defender Dave Ballinger.
How's that going?
It's going well.
Is it?
I think so.
Is he treating you okay?
You know.
Okay, we'll talk later.
We'll talk later.
Permission to practice is granted.
Thank you, Your Honor. I'm here with and on behalf of Darius Grady. Can you please state your name for the record?
Darius Grady. Thank you, sir.
Your Honor, we are asking for a 3-week adjournment on this matter, awaiting a mitigation letter.
No objection to that adjournment.
Probable cause conference will be adjourned to July 24th, 2022nd,
Was that July 20th?
2025. You know, did you catch the other one?
Yeah.
All right, July 22nd, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you, Your Honor.
That's all your fault. Court calls the case People versus Demond Bransford.
And Assistant Public Defender Nicholas Buckfitch on behalf of Mr. Bransford, who's now approaching. Bransford, can you please state your name for the record?
Demond Bransford.
At this time, Your Honor, we'll be requesting a brief adjournment. Mr. Bransford was interviewed by the drug treatment court people this Monday, so we're just waiting for a response to that.
Where a response you believe come before the 17th?
I believe we should be able to get a response by the 17th, Your Honor.
Probable cause conference, July 17th, 2025, 9 a.m. Bond continued. Court calls case People versus Cortez Gray. Oh, boy.
Reiser on behalf of the people.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Tortio Feaster.
Showing up in that North Carolina. He doesn't even understand why that makes my eyes go red. Permission to practice is granted. What are we doing?
Your Honor, we are requesting an adjournment in this matter. We were unable to get in contact with Mr. Gray, but now we have his correct phone number.
July 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court. What? Oh, it's right there. The whole North Carolina thing, like Tar Heels. Know the Tar Heels? Okay, that's why. Court calls case People versus Devontae Jackson.
Good morning, Your Honor. McKenna, this is Christine Attorney.
And Alex Warren Green on behalf of Mr. Jackson.
Yeah, what is this?
Mr. Jackson, can you state your name for the court?
Devontae Jackson.
You're on a today's date and time for probable cause conference. At this time, we are asking the court to set the matter for preliminary examination.
All discoveries complete?
I believe so, Your Honor.
And which people have their witnesses available on the 15th? Preliminary examination in this matter in person will be set July 15th, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you, Your Honor. I'll talk to you soon, Devontae.
Court calls case People versus Suzette Hampton.
Stephanie Cannon on behalf of Ms. Hampton, who's appearing to the right. Ms. Hampton, please state your name for the record.
Yeah, Suzette Hampton.
Your Honor, we're just asking for a 2-week adjournment on this matter for negotiation purposes.
July 17, 2025, 9 a.m. Bond continued. Thank you.
Do you need?
Court calls case of the People versus Paris Lester.
Hemant Adarsh on behalf of Mr. Lester. Can you state your name for the record?
Paris Alexander Lester.
You're requesting an adjournment.
We're requesting an adjournment, and I sent a motion to modify bond conditions to get him released into treatment, Your Honor.
You did it by motion as opposed to stipulation.
I believe it was a stipulation. I just
Pardon?
worded it differently. I believe it was a stipulation.
Really?
Yes, it
Usually
had,
those are signed by both sides. It's okay. Is there any objection to their motion? Okay, I'll grant your
thank you, Your
motion.
Honor. Yeah.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Court calls case People versus Marcus Harris.
And Alex Warren Green on behalf of Mr. Harris. Mr. Harris, can you
How you
state your
doing,
name?
Mr. Simpson? Marcus Harris.
I'm doing okay.
I seen you guys.
What'd you say?
It's been a minute since I seen you, but how you doing?
I'm doing okay.
All right.
You're back.
Been a while, but yeah, I'm here for the moment.
And you're like, so the last time you were here, were you allowed to wear shorts in my courtroom?
No.
No, right?
Should I put on to get here, put something on to get my butt up? Because last time you took me to the back for coming late. That was a while ago. So I'm sorry about that. I will make adjustment on this the next time.
You believe it? You don't know?
Oh, you're good.
All right, go ahead. I'm
Your
sure
Honor.
you will.
I'm asking the court to set this matter for a preliminary exam.
All discovery is complete.
So, Your Honor.
People have their witnesses available to 15. Preliminary examination in person will be set July 15, 2025, 9 a.m. before Judge Moore. Bond continued.
Thank you, sir. You have a blessed one.
You take care of yourself. Court calls case People versus Ahmad. Is it McWally?
I'm sorry. Thank you, Richard.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Matwally who approaches. Mr. Matwally, can you please state your name for the record?
Ahmad Matwally.
And Your Honor, if we may briefly approach on this.
Okay.
Thank
you. Any other, I've received and reviewed the report. Are there any other additional?
No other proofs, Your Honor, from the defense.
Nothing from the people we said. That's it.
All right. Based upon the report, the court has reviewed that report. The court would find that the defendant is at this time competent to stand trial, would specifically find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. And you wish this matter set for preliminary or for PCC, is that correct?
That's correct, Your Honor. One more extended PCC, and I imagine at that time we'll probably be waiving up to circuit court.
I'll set a probable cause conference in this matter for, given the circumstance you explained, I can, the 22nd or the 29th, or 22nd or the 31st.
My client is asking for the 22nd, Your Honor.
Got it. Probable cause conference, July 22nd, 2025. That's at 9 a.m.
Thank you, Your Honor.
Ron, continue. Thank you. She's doing. I know, but you didn't turn it.
Oopsies.
You took it. Yeah, follow through. Court calls the case, People versus Dashir Hassani.
Anna Mackey on behalf of Mr. Hassani, who is to my right. Please say your name for the record.
My name is Ardeshir Hassani. And my apologies for wearing shorts, Your Honor. I was not aware. And
I-
flip-flops.
Did you just come from the beach or something?
Mr. Brown told him it's summertime and hot in the streets. That's what Mr. Lauren Brown said.
Lauren Brown said that
Sure did.
and said that this was appropriate?
Look at him smiling back there.
Yeah, I know. I see him out there. Go take Mr. Brown's pants and come back. All right. I know Mr. Brown didn't tell us to show up there, but I don't know what man he's trying to say. What are you looking to do?
The green sheet, Your Honor, adjournment. We're waiting discovery.
Fine.
Thank you.
It's a green sheet. Probable cause conference will be adjourned July 17th, 2025, 9 a.m. Bond continue.
Thank you. And I'll make sure Mr. Hassani is in pants and shoes.
Thank you.
Will do.
Court calls the case, People versus Dale Miller.
Defender Hannah Apple appearing on behalf of Mr. Miller, who's approaching now. Mr. Miller, will you state your name for the record?
Dale Joseph Miller, the Alpha and Omega. Will you give this in, please?
Probably not, but I'll look at it first.
Okay.
Thanks. Judge, Mr. Miller was found incompetent but restorable.
Yes.
The opinion that I have has this case also listed on it. I'm not sure. I think maybe,
What's your date of your report?
I want to say it was like May 6th.
I have a May 8th
Okay,
report.
May 8th.
Opining that he's incompetent to stand trial, but likely to obtain competence was the proper course of treatment.
Correct. So I don't know if this one just got behind the other three, but I have an order prepared.
All right.
The court to sign. He's awaiting treatment at the forensic center. And just for the court's information, his next review date on those other three matters are the 14th of August.
Am I allowed to speak real quick?
I wouldn't recommend that.
I just want to let you know I'm the original son of God, the Alpha and Omega, mighty God, the only child conceived from Yahweh, Angelica, and the Holy Spirit. The devil is inside Barack Obama, Azazel. He was at Area 51. Simyaza, his sidekick, is inside Pope Francis. The book of Revelation is about me, and I have 12 sisters already that are down here too. Christ comes from me in heaven too. I sent him into this world. I created the heaven and the angels. Azazel kissed my wife Danielle twice in heaven. That's why he was put down here. He caused the fall, sending a male into the Garden of Eden to sleep with Eve. So he's paying the price now, and he is going to be dealt with soon. I'm going back to heaven soon. The rapture is going to happen soon, and I will come back after 7 years. I'm the Alpha and Omega, the Lion of Judah. Christ is the Lamb of God. I put everything in that note she's supposed to give you, but you guys won't let me speak. Lauren, the girl this case is over, is one of my 12 sister wives.
Okay.
And
all right, I don't.
I'm letting you know you guys haven't
Okay,
given me a chance to
let's
defend myself. I
talk.
try to let you know.
I let you talk, but now I'm done.
Okay, I've been warned. You will be dealt with. I'm the real judge of this world.
Okay,
You're
no,
going to
I'll
hell.
await that. September 4th, for 2025, 9 a.m. Round continue. You know, I've heard that same thing from Feaster. Every conversation I have with him. Every conversation with Feaster starts that way. I don't really think it's up to me. Court calls the case, People versus Alicia Henderson.
Maybe a risk for people.
Hannah Mackey on behalf of Mr. Henderson, who is to my right. Please state your name for the record. Alicia Henderson.
So that you know, because I criticized you. I felt safe that way. You got it. You got it. I just, thank you. All right, go ahead.
Your Honor, we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
Before we do so, Your Honor, I was not here at the last hearing, but I do know that we adjourned to explore restorative justice resolutions in this case. The notes that I have from the previous APA that cover indicated that both parties were in fact agreeable to the restorative justice resolution, which would have them at the Dispute Resolution Center, resulting in the ultimate dismissal of this matter, if that is successful. However, there was a bench warrant issued, I think, because she failed to appear at the last hearing, as well as the required paperwork not having been submitted yet by counsel. So I do want to confirm on the record before we set this for exam, that the parties on defense side, or defense rather, is rejecting the restorative justice resolution before we proceed to exam.
That is correct, Your Honor.
Which part?
All of
All of it? You're rejecting it?
We are.
We can go ahead and do what we were gonna do just about 20 minutes ago.
The bench warrant was recalled. because
Yes, it
my client
was.
able to-
That's why she walked in.
Yes, sir.
And now, what do you want me to do?
Set for exam, please.
Please? Oh, so why was Janaza like whispering?
She just wanted to talk to me.
So it wasn't anything about the case? No, okay, all right.
Go ahead, we'll sit down.
No, go ahead. What were you gonna say? I got all the time in the world.
Because the restorative justice resolution required contact, we normally request that those conditions are changed for consensual contact to, so that resolution can occur. I'm not certain if that happened at the last hearing or not, so right this moment, but before we are done with the case, I do want to confirm that standard no contact conditions are in effect.
My client hasn't been in contact with the complaining witness regardless, so.
I don't think we changed anything. No, I haven't. I don't know why I'm checking. Okay. So would people have their witnesses available?
What was that, they tried, I'm sorry.
15.
We will try our best.
Preliminary examination in person, July 15, 2025, 9 a.m. before Judge Washington. Bonds will continue. I don't see that any conditions were changed.
Okay.
So whatever the original conditions are still in. Court calls case People versus Sherry Nally. Or Nally.
Your Honor, whom I am appearing with and on behalf of Ms. Nally. And Your Honor, she will be waiving her right to a preliminary exam and proceeding to circuit court. I have gone over that with her.
Ma'am, is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution? People also waive their right?
Yes, ma'am.
Preliminary examination having been waived, defendant found over to circuit court on a single count.
Your Honor, we acknowledge the receipt of the information and would waive its formal reading and stand mute at this
Defendant
time.
having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 17th, 2025 at 1:30 with Judge Slay.
July 17th, 1:30, Judge Slay.
Thank you, Your Honor.
Bond will continue. Okay. Thank you. Court calls case People versus Dotton Howard.
Anna Mackey on behalf of Mr. Howard.
The shoes match too.
My nails too. They all match.
Oh, I was gonna do that. No, not. Go ahead.
Please state your name for the record.
Don Howard.
Thank you, sir.
Your Honor, request an adjournment. We're waiting for discovery. Our office has not received any yet.
Discovery.
Yeah.
The adjournment, I believe that anyone has that goes through the discovery process. So.
July 17th, 2025, 9 a.m. Bond continue.
Thank you.
So that's all I have left. Court does call the case of People versus Garrett.
Panagle, Your Honor.
Panagle, of course.
Assistant Public Defender Jay Bellinger on behalf of Mr. Panagle, who approaches. And Mr. Panagle, can you please state your name for the record?
Eric Panagle.
And Your Honor, while I can say that my client is not awaiting the rapture, he is awaiting a response as to.
You really didn't have to, but go ahead, sir.
He is awaiting a response as to 20 seconds recovery court. I just submitted him for that yesterday. I was informed by Ms. Sample that he will have an answer no later than the 24th.
and at which time I imagine we'll have some sort of resolution going up. I'm hopeful.
So is the answer you think coming on the 24th?
I think that they meet on the 24th, so I believe it will be.
Okay. So what I'll do is I'll adjourn this out to July 31st.
Thank you so much.
2025, 9 a.m. bond will continue.
I'll have an answer for you by then.
Oh, she's using her big words, asking me if we're doing recalls. Apparently, we are.
Thank you, Your Honor.
Thank you. I'm doing all this. Are they ready? Do you know if they're ready? Or you just hand it? What?
Insurrection.
I'm gonna call whatever. I know. Courthouse case, Tyler, people versus Tyler Redmond. Deal's ready. I'm just.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Redmond, Your Honor. Mr. Redmond, state your name for the record.
Tyler Redmond.
Your Honor, we're still waiting for an assessment to be done from the Circuit Court Sobriety Court. At this point, I would ask the court to, we thought.
From the 22nd?
Yes, yeah.
Sobriety Court?
Yeah, at this point, I'd ask the court to set an exam and we'll continue to look into that option as well. I've talked to the assistant prosecutor and I've told him that if there is an assessment done and we're in a position to waive or resolve, I'll certainly give him notice in ample time to call if any.
So he hasn't even been assessed.
No, Your Honor, we thought that was going to happen by the 26th, and I think they're a little bit behind.
So you want an exam instead of adjourning it to see if you can make that happen? I mean, either way, it doesn't matter to me.
If we have the exam, I can still do the assessment?
Let's set an exam, Judge, if the court's okay with that.
No, discovery is complete to your knowledge.
Yes, Judge, to my knowledge.
People have their witnesses available the 15th.
Yes, Your Honor.
Preliminary examination in person, July 15th, 2025, 9 a.m. That is before Judge Moore.
Yeah.
Okay.
Okay, all right.
Bond continue.
Thank you, Your Honor.
I'm sorry. Court recalls the kid. No, ready. No. Court calls case People versus Lakita Roberts.
If you're Richmond Deputy for the People.
What you do?
Mike Gaddy, Assistant Public Defender on behalf of Ms. Roberts, who's here to my right. Your Honor, state your name, Ms. Roberts.
Lakita Roberts. Thank you.
Welcome. Your Honor, I'd ask to set this matter for an exam.
For exam?
Yes.
All discoveries complete?
I have reviewed the file. Looks like it is, Judge.
I believe so. I did want to just confirm with Mr. Caddy.
I'm happy to talk about a global resolution. I've spoke with Mr. Ward about that as I was instructed to do, and he and I are going to continue talking, Judge.
Okay. People have their witnesses available this 15th. Your examination in person, July 15th, 2025, 9 a.m. That is before Judge Washington.
If I can be heard on time, Judge.
Sure.
Thank you. Your Roberts has been in custody for several weeks. Excuse me, I had a frog in my throat. She does have a place to live. She lives locally. She would, I think, I'd ask the court to give her an opportunity to avail herself of using a scram tether to ensure that her appearance in court, as well as any testing or other monitoring provisions that the court would deem necessary to ensure her appearance. I'd ask the court to, her bond is set at $25,000 in this matter. I'd ask the court to, she does have a couple other matters that are pending. She has the matter in circuit court that Mr. Ward and I have also discussed. I believe her bond is $50 in that matter. Her bond's $100. Her bond is $100, I think, in a 14B court, 14B district court case where I think the charge is a legal entry. So I'd ask the court to consider reducing this this bond to something that she may be able to post with or personal cognizance with any conditions that the court deems necessary to ensure her appearance.
Response.
Your Honor, I would object to any change of mind right now. Ms. Roberts also had a domestic violence case pending. I understand it was final settlement and may have been dismissed yesterday.
It was.
That was a newer case, however. Ms. Roberts, this case is a bit older. I looked at the previous notes, there was a big court issue, $25,000 cash assurity for failure to report to court as well as community corrections. I think a subsequent violation for community corrections as well. I'm concerned, obviously, about the substance use in this case. I don't think that, given her history of failure to appear and some new offenses in the interim and failure to appear on this case and other cases in circuit court, that we can trust Ms. Roberts to, on her own, comply with court orders and show up.
Your Honor, the DV case was dismissed yesterday in my note.
Does she have any other things pending at this point or no?
No, just this matter, the the illegal entry case in 14B, and there's a circuit court case with a $50 bond, Judge. There is a whole,
$50 bond in her circuit court?
yes, there's a,
Just because she had a bond in something else.
yes, that's my understanding. It's a very old case. It was bench warrant. I think, for some reason, I don't think the bench warrant ever got on lien because the jail didn't know about it until it was brought to their attention. During the
Motion for bond
pendency of this
reduction
case.
is granted. And the bond is set at $5,000 personal recognizance bond. Defendant is to report over, and we'll do new community corrections test. To report over for once a week testing.
Okay, thank you, Judge, and we'll work on the other bonds as well. Thank you.
Thank you, Your Honor. Thank you. Calls case People versus Timothy Stevens.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Stevens, Your Honor, who's standing here to my right.
Sir, your name?
Timothy Stevens.
Thank you.
Your Honor, at this time, we'd ask the court to set this matter for a preliminary examination. Ms. Tana and I have it, and I discuss it.
Have what?
Ms. Tana and I have had an opportunity to discuss this matter. We're going to set it for exam.
Discovery is complete.
Yes, Judge.
People would have their witnesses available the 15th.
I believe so.
All right. Preliminary examination in person, July 15th, 2025. 9 a.m. That's before Judge.
Thank you, Your Honor.
On continue.
15.
Court calls case People versus Leo Stringa.
And now it's Warren Green on behalf of Stringer. Just state your name.
Leo Stringer.
Thank you. I have before me two plea forms. It's going to be pleading to 2 counts of in 2 different cases to retail fraud, second degree to 1-year offense. On a successful plea to that charge, count 1 would be dismissed. There's also an indication that a case out of 14A2, which is a retail fraud 3rd degree, would be dismissed on a successful plea in these cases. That's all right.
And that's our full understanding, Your Honor. Mr. Stringer is asking the court to consider a no contest plea to both of those counts.
Do I have reports? It does say no contest plea. Yes, I do. I saw these reports. Okay. All right, may I have him some more?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, self you got?
I do. Leo Stringer.
Sir, it is this court's understanding that you are going to be pleading to 2 charges of retail fraud in the 2nd degree. Is that your understanding?
Yes, it is.
All right. Those are misdemeanors punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Sir?
Yes.
All right. You understand what a no contest plea is?
Yes, my attorneys described it.
All right. 2 things about a no contest plea. I have to make sure that you understand it. First of all, means that as to each of these cases, you have no desire or do not wish to contest these charges. You
No.
understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand also, sir, in one of your cases, the case ending in 5508, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valbo in the 15th District Court. Okay. You understand that? Basis for the no contest, please.
Lack of recollection, Your Honor.
All right. Sir, to the charge, I'll start with the 15th District Court matter. To the charge of retail fraud, 2nd degree. I'll just give you an offense date. Having occurred on November 20th, 2024 in the city of Ann Arbor, how do you plead?
No contest, Your Honor.
To that same charge, having occurred on November 20th, 2024 at 3825 Carpenter Road, that being the Meyer and Pittsfield Township, how do you plead?
No contest as well.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes, I have.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in there.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, actually, no, the probation that I was on I'm done with.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced?
No.
You're doing this voluntarily?
Yes, on my own accord.
And of your own free will.
That is as well.
The court has been provided and has reviewed University of Michigan Department of Public Safety and Security for their case number 24-903-06211, as well as Pittsfield Township Department of Public Safety report for their case number 24-19305. Any objection to the court having reviewed those reports?
None from the defense, Your Honor.
Based upon a review of those reports, the court would find that there's a sufficient factual basis to determine the defendant's guilt. Sir, you understand that if I accept your plea, in this case, between the time of the acceptance of your plea and the time of sentencing, if there's misconduct committed by you as defined by the Michigan court rules, you would, 1, not be entitled to withdraw your plea, and 2, any resolution or evaluation regarding this case, the courts would not be bound by in terms of sentencing. You understand that, sir?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea?
None from the defense, Your Honor.
Has the court complied with the court rule in both of these matters?
And the defense is satisfied.
Court will accept the defendant's plea of no contest to count 2 in both cases. Count 1 is dismissed. In the 15th District Court matter, a pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in the 15th District Court matter will occur on July 29th, 2025 at what time? 9 a.m. before Judge Balbo. In the other matter, court does accept the defendant's no contest plea to count 2, count 1 being dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in that matter will be July 9th, 2025, 9 a.m. before me. Bond in each of these matters will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. That's my favorite person. Clerk calls case people versus John Terry.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Terry. Mr. Terry, could you state your full name when you get up here?
John Martin Terry.
Thank you.
And Your Honor, I believe the court has received a plea form as well as a signed advice of rights form. Mr. Terry will be pleading to an added count 3 of controlled substance use, and counts 1 and 2 will be dismissed.
That is what the court has in front of us. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
John Martin Terry.
All right. He needs to acknowledge, box 5 needs to be checked on that form. Okay, sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance.
Yes, sir.
That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking the plea, I would not be your sentencing judge and you would be sentenced before Judge Farr in the 14A2 District Court.
Yes, sir.
Understanding all of that, you still wish to plead guilty?
I would, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have trial of any kind.
I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding those rights?
None, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
None whatsoever, yes, sir.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
I am guilty, sir.
On the date of August 9th, 2022, at the location of Prospect Road near Berkshire Drive in Superior Township, Washington County, State of Michigan, did you have heroin in your possession?
I did, sir.
Had you used it?
Yes, sir.
And did you know what you were using was indeed heroin?
Yes, sir.
Sir, I do have to advise you that if I accept your plea, if there is misconduct committed by you as defined by the Michigan court rules between the date of this plea and the time of your sentencing, any plea agreements and or evaluations, the court would no longer be bound by. You would also not be eligible to set aside your plea. You understand that, sir?
Fully understand that, sir.
All right. Counsel, are there any other pleas, threats, or inducements that have caused this plea that have not been stated on the record?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 15, 2025.
July 15, 2025. Time 10 a.m. before Judge Barr.
Thank you, Your Honor. And may I address bond?
What would the case be if you didn't? Go ahead.
Your Honor, so we did discuss this last week. I would just ask you to consider again a personal recognizance bond for Mr. Terry now that he has pled to a single misdemeanor. He does now have reliable transportation to court in the form of his mother and his own transportation. He has a job at tradesman that he could go back to. Again, he did admit that he had a slip up with regards to his sobriety, but he is committed to doing better. He's provided proof that he was enrolled in medically assisted treatment as well as mental health services through Packard Health and CMH prior to going into custody. And he had already completed an access interview with Home of New Visions and had planned to enroll in intensive outpatient treatment again prior to the bond violation, and would plan to do that if released, if Your Honor again would consider a personal recognizance bond.
So there's no plan set up for what he's going to do at this point.
There is.
It's my understanding that he was approved to participate in intensive outpatient through Home of New Visions. He would just need to contact them after he is released.
Yes, sir.
Anything from the people?
Your Honor, Mr. Terry has been able to provide through his counsel a proof of the treatment that he's been undergoing since February or March of this year. So we would leave it up to the court's discretion since he is.
Well, I'll tell you what, I'm going to deny at this point, but the reason my understanding is you would be shortly seen by 14A2's probation. And certainly that can be then addressed by Judge Barrs to his release. All right, consistent with what they see. So at this time, I'll deny your motion for bond modification. Bond will continue. But certainly
Thank you, Your Honor.
All right, thank you, sir. Good luck to you.
Sure, thank you.
Court calls the case, People versus. Is it? You have Bash. No, what about, do you have Huffman? Court calls the case, People versus Orby Huffman.
AP is reaching up.
Your name, sir?
Orby Huffman.
It says Mr. Brown as the attorney. That is not what, when did that happen? This morning?
I want to tell you yesterday.
Well, where's Mr. Burgess?
He did not
We'll have to stand in and ask for adjournment, Your Honor.
New counsel coming in. All right. Sir, I don't have the public defender had to withdraw from your case. I don't know if they discussed that with you.
No, they did not.
Okay. The reasons. There's a conflict of conflict of interest. It looks like because of the public defender's representation or prior representation of the complaining witness in this case. Okay. So they would have to withdraw. They've withdrawn. The appointing authority has appointed Mr. David Burgess to represent you. Okay, we have not heard from Mr. Burgess this morning. Don't know where he is. Quite frankly, even if he appeared today, he probably wouldn't have everything to be able to and have talked to you to make an intelligent decision as to what to do with it. Okay. And so he'd likely be asking for an adjournment anyway. So what I'm going to do, that's a long way of telling you, I'm going to adjourn your case out 1 week. Make sure Mr. Burgess has everything that he needs and then has the opportunity to come talk to you. Okay? Probable cause conference will be adjourned 1 week to July 10th, 2025, 9 a.m. Bond will continue. Thank you, sir. Pardon? What is- Court calls the case People versus Tariq Wilson.
For the people.
Morning, Your Honor. Andra Savary requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Akiri Ekenroli.
Is this the only thing she gave you today?
It's a small
What?
list,
Really?
Your Honor.
It's the only thing she gave you?
Yeah. So far.
Just been wandering around back there, like lost. And you didn't give her anything? Okay, fine. Anyway, your client's not here because he's not behaving himself and the facility would not sign in. Okay,
That's correct, Your Honor. At this time, we are requesting an adjournment for negotiation purposes.
okay, very good. Probable conference will be adjourned to the 17th, 2025 at 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. One case, really, Chanel? One case. One case. Court recalls case People versus Thomas Basher.
Austin Gilbase on behalf of Mr. Thomas Vasher, who is present to my right, Your Honor. Mr. Vasher, can you state your name for the record one more time?
Thomas Bashan.
Standing is that the defendant will be pleading guilty to count 2, the receipt and concealment of stolen property less than 200. Which is a misdemeanor punishable by up to 93 days in jail. Upon a successful plea to that charge, count 1 would be dismissed.
That is the correct reflection, Your Honor.
May I have it sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And
Thomas Bashan.
So it is this court's understanding that you are going to be pleading guilty or no contest to the charge. Is that this report? No contest to the charge of receipt and concealment of stolen property less than $200.
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it. I have to make sure that you understand. First thing is it means that you're not further desirous or wanting to contest this charge.
Yes, Your Honor.
Second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Yes, Your Honor.
Basis for the no contest plea.
Potential civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights? Look at paragraph 5. You say, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not that I know. No, not that I
No. Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Has anybody threatened you or coerced you in any way?
Oh, Your Honor.
You're doing this voluntarily
Yes.
of your own free will.
Yes, Your Honor.
All right. Court has been handed and has been provided and has reviewed Washington County Sheriff's Office report for their case number 255214. Any objection to the court having reviewed that report?
No objections, Your Honor.
Sir, I do have to advise you that any sentence evaluation and or agreement regarding your case, if you were to commit misconduct from the time I accept your plea to the time of your sentencing, that the court would not be bound by that. You understand that?
Yes, Your Honor.
You understand also that if you commit that misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that, sir? All right. Counsel, based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Is counsel aware of any other promises, threats, or inducements which caused this plea?
None, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
The defense is satisfied as well, Your Honor.
Court will accept the defendant's plea of no contest to this charge. The count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing in this matter will be July 31st, 2025, 10 a.m. That is before Judge Washington.
Here, may I address bond when appropriate?
If you want to, go ahead.
Your Honor, now that my client has dealt with this case, the only other case that we'd be holding him is a driving without a license case out of.
What?
Now that my client has dealt with this plea and the felony was dismissed, my client is asking to be released on a PR bond. The only other case that he has currently is a license case out of 14B.
And I would already given that would be reduced to the PR bond if I
Yes.
was reinstated.
Response?
Your Honor, given that felony is now gone, I don't necessarily object to the court reconsidering bond. However, I wouldn't. You have 3 pending board requests, one for fleeing third, in March, RO in April of this year, and a enforcement in the building from May of this year. At the time of this offense, defendant was in abscond status from circuit court probation.
Your Honor, my client asked that he once again be given a PR bond. If the court deems it appropriate, he can go on a tether. He has no issue doing that. He just wants to get out, hopefully get back to his job. His girlfriend was here for support, but she
Mr.
had.
Basher, it really is not helping your cause to sit there and try to mouth anything to me. All right? Because I'm trying to listen to your attorney and not pay attention to you.
Yes, Your Honor.
He does have some support here. She was here in the court waiting for him for about 3 hours, but she had to leave. As I said, Your Honor, the only other matter that would be holding him is a driving case. And these
Good.
These other charges that are pending have been pending for a long time. We haven't got anything, so
Are those gonna be coming forth anytime soon or what? I mean,
The APAs who are assigned to those wards aware and they look very chargeable to me, Your Honor.
also, Your Honor, my client has been in custody for 45 days now.
that's my biggest thing. All right, I will grant the defendant's motion to modify his bond. I'll set his bond at a $10,000 personal or cognizant bond. Defendant may be released on a GPS tracking tether prior, or can be released only with the GPS tracking tether in place, location tracking.
Understood, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. You're welcome. Court does call the case People versus Virgil Dunlap.
Andrew Charles, appearing on behalf of the people.
Edward Droops for Virgil Dunlap.
Your Honor, please state your name. Virgil Dunlap, I was appointed yesterday. I obtained the written discovery. There's some outstanding video discovery that I'm gonna ask for an adjournment to obtain.
Probable cause conference will be adjourned July 17, 2025, 9 a.m. Bond continued. Thank you. Court does call the case People versus Elton Bell.
Zachary Ward on behalf of the people.
Kevin Dodge on behalf of Mr. Bell. Your Honor.
Wow, it's been like 2 hours now since I go ahead. I'll let you go.
He's answering my phone calls. He said his ride is just not answering his phone. I would like to ask for an adjournment. He literally was going to come here, make a payment for his.
You want me to send the car for him?
I can help him with that next time. He doesn't have transportation. He's relying on people who used to work for him in the past to get here. I'm even inclined to have him learn Zoom so he's able to attend, so we don't have to worry about this in the future. I don't believe he's ever not appeared before, based on my notes.
You don't know.
So we are going to be asking for an adjournment, Your Honor.
Response from the people.
Your Honor, this is a larceny case where the defendant took a check from the victim for $2,000 and for I think over a year, they thought around to do the work, I'll pay you back sort of thing. And here he is supposed to show up and pay some money for a misdemeanor offer and he doesn't have a ride. We haven't seen photographic proof of him not having a ride. So
I don't know what that photographic proof of somebody not having a ride would be. Be sitting in my house.
She suggested it.
I don't know. It's a running joke.
Yes, that was.
And Your Honor, he is 65. He receives quite little Social Security. He doesn't work. He has injuries. We're trying to provide. He was going to come with documentation of his injuries.
Are you on the docket next week?
I should be.
Okay. So what I'll do is I'll adjourn it out a week. If he doesn't show up, then I take you into custody.
I'm okay with that.
You're okay? Okay.
Yeah. Thank you, Your Honor.
Good. She is good with that. Sounds like she is? Yeah. Oh, yeah. He's just like, yeah, she'll be.
Even if we're off, I'll be here.
Probable cause conference, July 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Mr. Dish didn't seem to care, did he? Okay. Are they present? The defendant.
They are.
Your Honor, I'm Special Assistant Attorney General Mitchell Wood for the people.
Good afternoon, Your Honor. Public Defender Crossing the Days on behalf of Mr. Biden, who's present to my right. Can you state your full name for the record, please?
Yeah.
Your Honor, we're going to be requesting about a month adjournment. There's negotiations going on between the AG's office and I. My client just needs some time. He's going to be contacting friend of the court to get hopefully maybe a readjustment due to a change in circumstances. So we just want to give him time to do that as well as make a payment so he can avail himself of the offer. So we're asking for about a month adjournment, Your Honor.
Any objection from the people?
No objection, Your Honor.
All right. Okay. Turn the matter to August 7th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you, sir. Court calls case of the people versus Donnell Young Senior.
Good afternoon, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Young, who's approaching, Judge.
All right, what are we doing?
Your Honor, last time, if the court recalls, this was at exam stage and was adjourned to see if we could resolve it. I have reached out. I've spoken with the Assistant Attorney General. I don't think he's the person who may be able to approve or a deviation from what I think the standard resolution is. I guess we could reset it, but I think it might be more prudent to adjourn this probable cause so I can have a conversation with that person. And I think given the week that it was set, I think that person's on vacation.
Who's on vacation?
I think the Attorney General who was here the last time, I believe she's out this week.
I believe Ms. Messer. Yeah, sorry, Judge, go ahead.
No, it's okay. I'll adjourn it to July 17th, 2025. 9 a.m.
Thank you. I do have a green sheet.
9 a.m.
Thank you, Judge.
Yes, sir. July 17th.
Thank you very much, Your Honor.
Thank you.
Court calls the case of the people versus Dominic Kelly Payne.
Your Honor, Alexis Pluma, I'm appearing on behalf of Mr. Kelly Payne, who is present over Zoom. Sir, could you just state your full name?
Dominic Kelly Payne.
Thank you. And Your Honor, I do have a green sheet here. We are requesting a 2-week adjournment for plea negotiation purposes.
They should be doing these plea negotiations, quite frankly. I will adjourn this out July 17th, 2025, 9 a.m. Continue.
Thank you, Your Honor.
Thank you. Court calls case people versus Montez King.
Good afternoon, Your Honor.
Yes, Your Honor, Assistant Public Defender Nicholas Bukovich on behalf of Mr. King, who should be appearing via Zoom.
I'm here. Mr. King, state your name.
Montez King.
Got him.
Yes, Your Honor, at this time, we'll be requesting a brief adjournment. There's still some potential outstanding discovery from a search warrant from June of last year. The detective who APA will be reached out to about this is out on vacation this week, should be returning next week. So he's want to make one more confirmation before setting this matter for a preliminary exam.
You don't have an objection to the adjournment, just to indicate to council that a search warrant return could take time. I don't know when it will be back, so I don't want to give the illusion that this.
You're going to have it. I was going to ask that question myself. Why don't I?
Yes, that's understood, Your Honor, but just before we set this matter, my client would like to see.
Pardon?
I said that was understood, Your Honor.
July 22nd, 2025, 9 a.m. Come on, continue.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Sheldon Lewis.
Please, I retract that statement. Sir.
Permission to practice is granted.
Student Attorney Kara Rosengren on behalf of Mr. Sheldon, Your Honor.
Yes.
Can you state your name for the record?
Yes, Sheldon Lewis.
Sheldon, I didn't bring my whole pants. Lewis. All right, go ahead.
Your Honor, we're respectfully requesting that the court set this matter for an exam.
Discovery is complete.
Yes, to my knowledge, Your Honor.
People have their witnesses available the 15th. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Moore. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you. Court calls case of the people versus Derek Martin.
Stephanie Cannon on behalf of Mr. Martin, who's appearing to my right. Mr. Martin, could you please state your name for the record?
Eric Martin.
Your Honor, we are going to ask for an adjournment. Making sure. Do you have a green sheet?
Excuse me?
You already have a green sheet, Your Honor. There's a green sheet for you, Your Honor, regarding that request for an adjournment. We're just waiting for.
Why is she asking me? What? No, you had the thing. Why did you ask me if I had it?
You're right, Your Honor. I don't know what I was thinking. Your Honor, we're just looking for some discovery. The prosecutor's office has let me know that they are working on it for me.
Your Honor, it is already to get time the hard disk was not actually.
Probable cause conference adjourned July 17, 2020.
I'll call you.
You had a green sheet? The one I have. No, don't try it. She's trying to catch me up. Court calls the case, people versus Kaida Matson. Oh, all right. You've been quiet over there, just sitting. Okay. They won't let you do anything? Really? Why did they say? Hold on a moment, I got it, buddy. Why won't they let you do anything? Oh, that's. We had to give her a mental health. Thank you, Ms. Stanley. Makes me feel better. Never mind, I'll quit inquiry.
Good afternoon, Your Honor. Assistant Public Defender, Nazi Carey, I can ruling on behalf of, but unfortunately not with Ms. Kaida Matson.
What happened?
I don't know that. We have not been able to make any contact with Ms. Matson, and we don't have an explanation to the court for her failure to appear today.
Might it be a bond violation?
I thought about that. I did. Very possible, but I don't know, Judge. Yeah.
This is your first case.
It's
spectacular. Good job.
Thank you, Judge.
Warrant will issue for defendant's failure to appear. $25,000 cash surety. That warrant will issue immediately. It already has a no bound. Oh, that's right, because then I'll continue the no bound. Really? Did you really say that? That's what I did. Court calls the case people versus Kevin McCullough.
Good afternoon, Your Honor. Assistant Public Defender Constable Basie. On behalf. No, my trauma is over. I'm good.
I'm glad it worked out.
On behalf of Mr. McCullough, but not with Mr. McCullough, Your Honor. The word I received from him is that he checked himself into rehab this morning. The word I received from him is that he checked himself into rehab this morning. I still haven't received the proof. I don't know, maybe he's still on the bus on his way there.
Any advisor on behalf of people who request a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in a matter of $10,000 cash.
And I think he has an old corrections.
Oh, he's got a CC.
Yes, sir.
25,000. Cash surety.
Thank you, Your Honor.
For the people versus Keisha Malfoy.
On behalf of Ms. Malcor. And ma'am, could you just state your full name for me?
Keisha Melcher.
Thank you. Your Honor, we are requesting an adjournment today. We have just provided the people with some new information that they will need to review to see if we can work out a misdemeanor offer.
Probable cause conference will be adjourned to July 22nd, 2025.
Your Honor, I have for July 22nd in Taylor.
I'll make it the 17th. July 17th, 2025, 9 a.m. I'm continuing. Thank you.
Thank you.
Thank you.
Thank you, ma'am. Court calls case, people versus Vanish Mitchell.
City Attorney Kara Rosengrant on behalf of.
Mitchell, could you give your name for the court? Lanish Mitchell. Your Honor, we're going to be requesting an adjournment in this matter as we're still awaiting video discovery.
Probable cause July 17, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Case of the people versus Keith Moore.
Hello? I mean,
Hello.
good morning, Your Honor.
Good afternoon, sir.
And Alex Warren Green on behalf of Mr. Moore. Mr. Moore, can you state your name if you haven't already?
Keith Moore. Keith Jarrett Moore.
Thank you, Mr. Moore. Your Honor, today's date and time for probable cause conference. At this time, I am going to ask the court to set a competency hearing. I have prepared a proposed order.
For a forensic evaluation.
That is correct, Your Honor.
Forensic evaluation will be ordered outside of comp hearing room 90, please.
October 2nd.
Set a competency hearing for October 2nd, 2025, 9 a.m.
Yes, Your Honor.
Thank you. Bond will continue. Court calls case people versus Megan Moses.
Christina Rivera for the people.
I'm here.
I need a cameraman. Oh, thank you. State your name, please.
Megan Moses.
All right, go ahead.
Thank you, Judge. I just speak to Mr. Ward about this file. He did show me a receipt for about $827 of restitution. Ms. Moses has to pay that in order to have this matter reduced. So we're asking for about 4 weeks. So she's trying to get that $827 paid and then resolve the misdemeanor resolution.
She paying it.
Yeah. And then I'm gonna ask you if we can change the bond to add it as a, so she can pay the court, to make it a bond payable to the court.
What?
I don't know what the term is, isn't it, the court makes it into a bond, and I believe she can pay you the $827.
This is causing me trouble.
I apologize, Judge. This is my first case of the day. I'm still.
I know.
I'm still
I was fine up until this.
No, it's fine, man. It's been a rough day. We apologize.
Into court. How much was the
$827.
$827 to be held for restitution?
That's what I was asking for, Judge. Thank you.
I'll adjourn probable cause conference into August 7th.
You understand that, Ms. Moses? Can she hear us?
She didn't hear any of that.
No.
Ms. Moses? Hear any of that, ma'am?
It cut out a little bit. I didn't hear much. Sorry.
All right. You're allowed to pay the $827 into court as bond to be held for payment of the restitution. Okay? You have to pay that at the 14B District Court in Ypsilanti Township.
Okay.
Okay? I'm adjourning your proceeding out to August 7th, 2025 at 9 a.m.
Okay. So do I have to have that fully paid by then, or I guess what is the?
As you spoke to Ms. Akari on the phone, we need this paid as soon as possible. So we'd like you to try and get it paid by that date, so we can get this matter resolved and closed out for you.
Okay, and then the tether as well, will that be able to be removed?
It will not today.
Okay?
Okay.
Thank you.
All right, thank you. Court does call the case. People State of Michigan versus Rodney Napier.
Okay, Rachel McDuffie for the people.
Council Delisi, on behalf of Mr. Napier, but not with Mr. Napier.
What are we doing?
Your Honor, I would be asking for an adjournment. I have not had contact with my client. So something needs to be done about these buses, Your Honor. They're causing me trauma.
Bench warrant will issue for defendant's failure to appear. Bond is any amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case People versus Nicole Nelson.
The public defender, Nazi Carey, I can really, Your Honor, on behalf of, but unfortunately.
I know. Do you have a client on either one?
They just don't like me today. No. Not the
So this is number two.
maybe the number two, Judge.
They might be all on the same bus.
It's possible.
Bench warrant will issue for defendant's failure to appear. Bond will be set in an amount of 10,000 cash surety. That warrant will issue immediately.
Keep that.
Court calls the case of the People versus Antoine Patterson.
Ready, Judge. Mr. Patterson. Please state your name for the record, sir. He apologizes for not having on pants. Mr. Bellinger did not tell him he had to wear pants. So.
Oh, yes, also, oh my God. Oh my God. Oh, and it's laundry. Yeah, like I missed when I was supposed to go to the whole clinic, and I missed that when it was like 98 outside, and I was supposed to go to the whole clinic yesterday. Well, I don't remember the day, but we were scheduled for Monday, and I got like 4 big bag of clothes, and I actually wore these already, and I only got my right belt. Like
He apologizes, Judge, for not
to
having
the
pants.
deepest of depths of my apology. I apologize. Sorry. What's that?
There's a lot more information.
He does have colorful socks, Judge.
What?
He does have nice colorful socks, though.
You picked those out on purpose. No, I'm kidding.
So
I get it.
the court should have 2 things in the file, Your Honor. If the court's willing to do a plea, we have a plea and advice of rights in the form. If it arrives too late, we also have a green sheet for an adjournment, Your Honor. So whatever the court's pleasure.
Or you be too late in form.
Okay.
It's not going to be a no contest.
No, Judge.
All right. So be pleading, what the plea form indicates is that pleading guilty to domestic violence.
Yes.
That being count 2, count 1, the child abuse, 3rd would be dismissed. There is, the defendant is agreeing, actually also prosecutor and defendant. Yeah. So it's actually checking both 3 and 4 that they're agreeing to 76948, 2 years probation. The offer is considered on the defendant having no assaultive contact with the minor victim or anyone else since the incident date of the case. No contact with any minor children and others. But I want to make sure the court's understanding is that I read that to mean that if there is a accusation that comes up that is not known at this point.
Slight modification, Your Honor. So there has been allegations, and I know both sides have tried very diligently to figure out what those are specifically, and you're just not getting enough information. So I'm interested in moving this forward. We've tried quite a few times. It's contingent on if I receive information or anyone receives information that the victim has been harmed in any way by the defendant since the incident that underlies this case, then that means everything, we withdraw the offer and, of course, you know, the plea with that.
That you're in.
That is what Mr. Bellinger negotiated, yes, Judge.
Wow. Okay. And so
Right. You solemnly swear to affirm the testimony. So be God.
Yes.
State your name.
Antoine Patterson Sr.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of domestic violence. Is that correct?
Yes, sir.
That is a misdemeanor punishable after 93 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. You understand also, sir? Forgetting this.
Oh, shit.
I just checked.
Oh.
I want to make sure he understands.
Okay. he won't be here.
In this matter. You understand that, sir?
Yes, sir.
You would be sentenced before Judge Washington.
Yes, sir.
All right. Now, understanding all of that, do you still wish to plead guilty?
Is it okay to ask a question?
Sure.
Okay, so, when you say sentencing, I get to the sentencing, court date, the 2-year probation thing and the 4A, that's when I lose my probation, I'm off, like, I don't have to try to get it expunged, correct?
I think what he's asking is if he successfully completes his
When
probation
I
under
successfully-
4A, will it be removed from his record per the statute?
And the probation is what I'm going under, so when I get to the sentence, he just want to sense if it's, is it like for sure 2 years probation, or can it be up to 2 years?
The way I read this plea agreement is that you're agreeing to 2 years probation.
Okay, yeah, that's fine with me.
Okay.
Just want to be clear, yes, let's
Okay.
get one plea guilty.
You still want to plead guilty?
Yes, sir.
All right. You have any other questions?
No, sir.
All right. To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed it advice rights form.
Yes.
Is that
I
correct?
believe so,
Any
yeah.
question regarding those rights?
No, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
All right. On the date, did you wish to provide or you want me to provide?
Would you, I would prefer you to, Your Honor.
Okay, no, that's fine. That's fine. I just didn't know in terms of specifics. On July 8th, 2000, between the dates of July 8th, 2024 and July 9th, 2024, at the location of 2871 Bunning Drive, apartment 308 in Ypsilanti Township, Washtenaw County, state of Michigan. What did you do that makes you think that you're guilty of this offense?
I had a lapse of emotions of erratic and made an erratic decision on impulse of high concern.
And what did you do?
I hit a kid and I hit him. I gave him what I feel was a whooping.
Was this child in your household?
Yes, sir.
All right. And so that you had that relationship with the child that you lived together.
Yes.
All right. And I'm a little bit concerned as to you intentionally did the acts to this child that, as you say, constitute a whooping.
Say that, I'm sorry, say that again, please.
The acts that you did intentionally.
Intentionally? No, I don't want to say like I didn't intend to, you know what I'm saying?
Okay.
Can I help you?
Stop you right there. Because, go ahead.
Thank you. What Judge is asking you, I think you had a conversation with Mr. Bellinger before he left, was you had a relationship with this child that lived in the home with you.
Mm-hmm.
And that's a yes?
Yes.
Okay. And you proceeded to hit that child.
Yes.
And you knew what you were doing.
Well, yeah, I mean, pretty much yes. So yes.
Well, pretty much yes, or
yes.
So you knew what you were doing, and you whooped that child, correct?
Yes.
And that could be considered by some, the prosecutor, in excess of what was appropriate.
Yes.
That's a yes?
Yes.
If the court wants to adjourn for Mr. Bellinger to have more conversations?
I think I'm not going to accept his plea. I'm a little bit concerned.
Okay.
Based upon what you said.
Pardon? I'm sorry, I spoke out of turn.
No, go ahead.
Okay, so this has been going on for a while. I'm trying to get the sentence under it because when I went to Michigan Works to try to get into the electrician.
Okay, this is me, sir. The problem is, and I understand you may be wanting to move this along, the prosecutor wants to, everybody wants to move it along. The difficulty is for me is I have to be assured and convinced that you're voluntarily pleading on this, number one, and that what you are telling me you did would constitute this crime.
Okay.
All right. Because of the way that you answered some of the questions, I'm not saying it's answered wrong. I'm just saying these are my concerns. Because of the way that you answered the questions, also because of some of the things and hesitation that you had in response to questions, I have some concerns as to whether or not you believe that you may be guilty of this offense. And so, for your protection, as well as the protection of the plea and the integrity of the plea, I'm going to adjourn this. I'm not going to accept your plea today. I'm going to adjourn this out and allow you to speak with counsel.
Okay.
Some additional time. All right.
All right. Thank you, Mr. I appreciate it.
And what I will do then is I will adjourn this to the 17th.
Thank you, Judge.
at 9. On the 15th.
Thank you, Judge.
Court does call the case of the people versus Paris Pope.
Secretary for the people.
Stephanie Can, on behalf of Ms. Pope. Ms. Pope, when you're at the lectern, please state your name for the record. Paris Pope. And Your Honor, we would be asking for this to be set for a preliminary exam.
Is discovery complete?
No. But Your Honor, it's not discovery that we need for the preliminary exam. I have requested it. I believe they would likely have it too before the preliminary.
What is it? Because
The best footage. I still have the best footage.
the body cam footage?
Yes, that is correct.
Your Honor, if I may, I'm sorry, Kevin. When I looked at this file, I saw that it was a brand new case, and as far as I could see, the other day, we didn't actually have any discovery turned over to the people office. If Ms. Cannon, that's fine, but I would think.
I have the police report. I have the information. Other thing I have is the body cam footage, to my knowledge.
Okay. I'll defer to the court and Ms. Cannon if they're still.
I let my client know this. My client is asking for a preliminary exam. I've explained to her that the court will not adjourn it for that reason if we don't have it.
Correct.
And she is trying to move forward, Your Honor.
And ma'am, so that you understand, if something appears on that body cam footage that's beneficial to the people and they intend on introducing it, I'm not going to hear any objection from your counsel that you haven't had the opportunity to see it.
Okay.
And adjourn it. You understand that?
Yes.
People have their witnesses available the 15th.
July 15th.
Preliminary examination in person, July 15th, 2025, 9 a.m. That's before Judge Washington.
Thank you.
Thank you.
Thank you.
Thank you. Oh, are you leaving us? Are you leaving? No, are you leaving? I mean, you could say you're leaving.
I don't know if I can.
I don't.
Yes.
You can.
Yes.
Well, you have a wonderful holiday.
Thank you so much, Your Honor. Thank you.
I was actually going to express how sad I was that you were leaving us. But I am sworn to tell the truth. What? You like brisket? Oh, yeah, me too. So I'm keeping mine. Court calls the case of People Say Michigan versus John Riggs.
And Alex Warren Green on behalf of Mr. Riggs. Mr. Riggs, can you state your name for the court?
John Riggs.
Your Honor, today's date and time for probable cause conference. At this time, we're asking for an adjournment. I've completed a green sheet here. We want Mr. Riggs to speak with a social worker and at least begin a mitigation report. Thank you.
You've seen the community correction progress report?
I have, Your Honor. I reviewed that with Mr. Riggs. Your Honor, I see that he was late on the June 29th test, at which point he returned an alcohol detection of 0.006. Of course, I reminded him to be on time and of course not drink. He is in sobriety court while he's in the felony recovery court. I think he has a strong support system, but as the report reflects, my client does deny consuming alcohol.
Did he take a retest on that?
I'm not sure, Your Honor. I think if this is going to be treated as a violation, I would be asking for a hearing and the long form SoberLink report so that we can see any potential retests. And so we can have that looked at by a PBT expert.
So I'll set a bond hearing as well as the adjournment of the probable cause conference. I'll set that out to the 17th, 2025. Actually, that's going to be at a 3 p.m. block because we'll have bond violation here. We'll continue this time.
Thank you, Your Honor. And a probable cause conference at the same time.
Yes.
Thank you.
You'll just be in a flat block. That is in person, not if you're facing.
Got it. Thank you, Judge.
Court does call the case People versus Terrell Stevens.
Mike Getty, Assistant Defender on behalf of Mr. Stevens, who is here present by Zoom, Judge.
Yes.
Judge, we'd like to set this matter for an exam.
All discovery is complete.
I reviewed it. It looks complete, Judge.
You will have the witnesses available to 15. Preliminary examination will be set July 15th, 2025, 9 a.m. That is before Judge Moore. In person.
Thank you.
Thank you.
Okay, thank you.
Thank you. Courthouse case, People versus Colin Vanderbilt.
Civil defendant advocate on behalf of Mr. Vandermeer, who should be appearing via Zoom from treatment. There he is.
Oh, there he is.
Mr. Vandermeer, will you state your name for the record? Thank you. Your Honor, I have a green sheet. We're asking for an adjournment. Mr. Vandermeer is still awaiting treatment at the forensic center. He was found incompetent but restorable in November.
Right.
I did send an email to the CFP to see if we could get an update, but I don't have a response.
So he's waiting to get himself enrolled in treatment.
Yes. I think it's up there. That was.
This is a reset of the review.
Yes.
Is that what it is? Okay, got remarked. All right. Just bring him back and forth. Why don't I set it for September 25th? Okay. And then that way, if we get some updated information, we'll figure it out before then, but we'll just do that. Defendant's bond will continue. Okay, thank you, sir.
Mr. Vandermeer, your next court date, September 25th. If you have any questions, give our office a call, okay? Thank you.
Court calls the case People versus Tyrell. Alex, is it Casara?
That's where I watched this here.
And Assistant Public Defender, Matthew Carey, I can rule, Your Honor, on behalf of Mr. Ross Basara. Yes, sir.
Well, we have a client show up.
My client is here, Judge. That's right. Your Honor, we are ready. The people sent over a plea form to us on yesterday. Unfortunately, we weren't able to get everything into the court by the deadline, so we do have a resolution. We're asking for a brief adjournment wherever the court deems sufficient to review the document.
Everything you think is resolved?
Yes, Judge.
Now, but I'll put it over to the 10th, 2025. Just put it on a week. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, sir. Is that everything? It is? 2 o'clock, we gotta come back and do this tomorrow? Who's gonna be here? This one gonna be here? Oh, she doesn't have any cases. She's traumatized. All right, what? I'm being mean again? Okay. No, you haven't seen me. I can, never mind. I shouldn't say it on record. Court is staying in recess. All right, what do we do?
Your Honor, there should be a green sheet in Your Honor's file asking for an adjournment for further negotiations.
How much time do you think you need?
2 or 3 weeks, Your Honor, would be perfect.
I've got the 17th or 22nd.
17th, please, Your Honor.
17th. Probable cause conference will be adjourned July 17th, 2020. 9 a.m. Bond continue.
Thank you very much.
Thank you, Mr. Brown. Is that it for you, Mr. Brown?
No, Your Honor.
All right. Can you just approach us?
Yes.
Court does call the case People versus Bryn Delmy, DeLorme.
And good afternoon again, Your Honor. Dan Guerin on behalf of Bryn Delormier. Bryn, can you identify yourself, please? She's muted.
Hi, can you hear me?
Yes.
Okay. Hello, Your Honor. This is Brenda Lormier.
Okay. I have before me a plea form. Is that what we're doing?
It is, Your Honor.
Plea form indicates that the defendant will be pleading guilty to the charge of operating while visibly impaired. The 93-day offense. Upon their successful plea, that charge count 1 would be dismissed. That is the court's full understanding of it. Yes, counts 1 and 2 will be dismissed. It was further down. Got it.
That's our understanding as well, Your Honor.
All right. Very good. Ma'am, could you please, you usually said you've got one for me. Thank you, sir. Ma'am, could you please raise your right hand?
Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record, please.
My name is Bryn Delormier.
All right. You can put your hand down.
Okay.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor, punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. Could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes, Your Honor.
All right. Court further has to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I'll plead guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor. I have it here in front of me.
All right. Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily,
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of April 22nd, 2018, at the location of westbound I-94 in Scioto Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed or ingested intoxicating liquor?
Yes, Your Honor.
Do you recall what you had and how much?
I believe I had a few glasses of wine earlier that evening, but it would have been the previous day, the 21st.
All right. Were you stopped by the police
Yes, Your
or
Honor.
was there an accident?
I was stopped by the police. They introduced themselves as peace officers. There were two of them. Yes, Your Honor.
Do you know why they stopped you?
They said failure to stay in my lane.
All right. You're not disputing the right of the police to stop you in this instance, are you?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital for a blood draw?
Yes, Your Honor.
All right. Do you recall what the results of that blood draw were?
They didn't share them with me at the time. I just learned about them recently.
Your Honor, we'll stipulate for the plea was a .103 blood result.
0.103 blood.
Correct.
All right. Thank you. Ma'am, do you have any reason to dispute those blood test results?
No, Your Honor.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle is visibly impaired due to your consumption of alcohol?
I'm sorry, could you restate that, please?
Sure.
Thank you.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
Ma'am, I do have to advise you that if I accept your plea, there is no recommendation or evaluation. But however, if you commit misconduct between the time of my acceptance of the plea and the time of your sentencing, that any evaluation or recommendation, the court would not be bound by. You understand that?
Yes, Your Honor.
And you also understand that if you did that, you would not be permitted to withdraw your plea.
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea to occur?
No, Your Honor.
Has the court complied with the court ruling? Would it be proper to accept this defendant?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will occur
September 22nd, 2025 at 9 a.m.
September 22nd. Okay. September 22nd, 2025, 9 a.m. before Judge Freshour. Bond will continue.
Thank you very much, Your Honor.
Thank you. Thank you, ma'am.
Thank you, Your Honor.
Court calls the case of the people versus Dean Keenan.
Good afternoon, Your Honor. Advisor, on behalf of the people.
Good afternoon, Your Honor. Dan Garrett on behalf of the.
My name is Dean Keeler, Your Honor.
Your Honor, I'm asking for an examination on this matter.
All right. All discovery is complete.
I believe it is, Your Honor.
All right. People have their witnesses available to 15.
You said another case with a victim in the case. Could we have the next available date of Michigan?
I can't. Can we possibly keep it on 15th? Otherwise, I'm going out pretty far. Thank you, Mr. Roger.
Preliminary examination, July 15th, 2025, 9 AM. That is before Judge Washington. It is in person. Bond will, with its conditions, will continue.
Thank you very much, Your Honor.
Court does call the case People versus Jose Montalvo.
Afternoon, Your Honor. Dan Garrett on behalf of Mr. Montalvo. I see him on Zoom. Jose, can you identify yourself?
Jose Montalvo.
Thank you.
Your Honor, he's been accepted into the drug court, so there'll be a straight waiver today.
Okay, straight waiver. Sir, you're waiving your right to a preliminary examination?
Correct, Your Honor.
You understand that that is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. Do you understand that?
I understand, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Correct, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we'll waive reading of that single count. Stand mute, please.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
September 26, 2020. Oh, August 26, 2025, at 1:30 with Judge Hopkins.
August 26, 2025, 1:30, Judge Cook. Bond will continue with its conditions. Thank you.
Thank you very much, Your Honor.
Thank you, Your Honor.
Is that it for the Garrett? Is that- All right. Court does call the case People versus James Chandler.
Good afternoon, Your Honor. We please this honorable court, Brandon Bird on behalf of James Chandler wearing pants today, Your Honor.
Well, see, we all learn, don't we?
Mr. Chandler, please state your full name for the record.
James Chandler. You promised me you wouldn't come back that way, so you're it. You're it. All right, what are we doing?
Respectfully, we'd like to set this matter for exam, Your Honor.
Your Honor, if I may, I believe Ms. Sanda sent the amended information to the court and defense counsel. Let me make sure.
I have it.
Are received. I do have that here.
I don't believe I have it.
Today,
Yes, today.
there's an amended complaint adding,
And Your Honor, well, it's a change really. It's a domestic violence second offense as opposed to first offense.
got it.
So I can do, counsel indicated to me that he doesn't have it. I can have it printed and counsel for you.
Good. Okay. Saying nothing so much. Got it. Ms. Tanner, don't worry about, we'll print another copy and get it to council. All right, would you, to the extent that, actually, I don't know that he needs to, but you would acknowledge the second offense notice in the amendment?
I acknowledge the offense notice.
All right. And just so that, well, so you waived the reading on count 3. Here's the way, because here's how it had to be done so that we're clear. Counts 1 and 2 existed. They couldn't just add the second offense notice. I guess they could theoretically, but I don't think so. So count 3 is then added as the domestic violence second offense.
Okay, Your Honor, way to read it, stand.
All right. Your client would stand mute, so I'll indicate that he was arraigned on count 3. And so if I set this for exam, is that what you want, sir?
Yes, please, Your Honor.
And so all discovery is complete.
Correct, Your Honor.
All right. And would the people have their witnesses available on the 15th? All right. Preliminary examination in person, July 15th, 2025, 9 AM before Judge Moore.
Good to hear.
Bond will continue with its conditions.
Thank you, Your Honor.
So we'll get that right to you, Counsel.
Thank you, Counsel.
Thank you. Court does call the case People versus Leon McEwen.
And those are the people?
And yes, Your Honor, Brandon Bird on behalf of Leon McEwen. Mr. McEwen, can you please step to the podium? State your full name for the record.
Yeah, McEwen.
Thank you, sir. What are we doing?
I'd like to,
For an adjournment?
no, Your Honor, we like to set this matter for exam.
Okay. Yes, sir. Discovery is complete.
It is, Your Honor.
People have their witnesses available to 15. Preliminary examination in person will be set July 15th, 2025, 9 AM. That is before Judge Washington. Bond will continue.
Thank you.
Hang on a second. Is everybody?
It was a report.
I got it. Is there one? Hang on a second. I don't know if we have a violation report.
I believe I received that today, Your Honor.
You did? I don't have. Is he here? You knew I was gonna ask you. You're printing it today. Okay. All right. Anything you want to say regarding this violations?
First of all, we'd like to apologize to the court and the prosecution for making representations that my client was clean. I just received a report today and I was going off the indications of my client, in which he apologized to me and he wants to apologize to this court.
Well, but I mean, I understand the apology, but he had, by telling you what he told you, he had you give certain representations to this court.
And believe me, we had a long discussion about that.
I'm sure you did.
We did. I believe my client maybe was embarrassed. I did, after discussing this with my client indicates to him that he did relapse. The stress of this case was helping him relapse, but he said one thing that really mattered. He said, it's not an excuse. And I understand that my client is taking accountability for this situation.
So he admits to this violation.
He admits to it, Your Honor.
Go ahead.
I believe my client takes accountability for this situation. He really came to me and said, I'm really trying to straighten out. He understands that he needs help straightening out. I understand that addiction is more of a disease. And I believe there's better ways that addiction can be handled besides being in the confines of jail. My client will take, he is trying to take conditions serious, Your Honor, but my client suffers from addiction. He suffers from that disease. And he understands that he needs that help. And he actually indicates to me that he reached out and has been searching for help. He could tell you, I know Domino Farms was one of the places, correct?
Yes, sir.
And he was telling me other aspects, other avenues that he was looking at to get that help. We just asked that this court have leniency, and we're coming to beg your mercy on this matter. And after this court have leniency on my client, maybe even allow him in inpatient treatment, Your Honor, instead of having them behind bars.
Anything from the people?
Your Honor, as the court may remember, yes, last time we were here, we were going to set it for exam, and I put the offer on the record that it was that if Mr. McEwen provided proof that he had undergone some treatment since the date of this offense, that he offered that misdemeanor, and Mr. McEwen had interrupted and said he'd been in treatment for 5 years. Mr. Bird later, the adjourned, Mr. Bird later came to me to tell me what the proof was, and while I respect that Mr. McEwen represents that he was for some time clean, I believe that he needs some help from some sort of a program. And so I do not think at this time that he is able to comply with the bond conditions if he's not in a program.
Anything else, Commissioner?
I respectfully, Honor, I'm asking if there's any way possible that my client, if he does go to jail today, could he be released to some sort of inpatient treatment?
I will always sign an order that allows him to be released to treatment, but what he's not going to do is come before this court, violate our bond conditions, then lie to counsel, have that lie, then go to the court and think that somehow or another he's going to get over on the system. It doesn't work that way. And it certainly doesn't work that way with me. All right. Because I know that if his circumstance, if he had told you the truth, Mr. Bird, you would have made sure to try to communicate in some way to this court. Not only just in terms of your ethical obligations, but also just in terms of trying to make sure that the right thing gets done, because that's the way that you are. So I think he's let down a whole lot of people, most of all himself. So at this time, certainly I will entertain anything, but this will go before Judge Washington on the 15th. But in the interim, defendant's bond is revoked. He's remanded. Court does call the case of the people versus Adrian Gearman.
Yes, Your Honor. Brandon Bird on behalf of Adrian German, standing in for Hassan Hamadi. Mr. German, can you please state your full name for the record?
Yes, Adrian German.
German. All right. And you have no objection to counsel standing in?
No, sir.
You're standing in for somebody?
Correct.
Yeah. You have no objection to that, sir?
No, no.
Okay, go ahead. All right. You're asking for adjournment?
Yes, yes, Your Honor.
All right. PCC in this matter will be adjourned July 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. You and Your Honor, before, have a great day.
You do the same. Court calls case of the People versus Matthew Newton.
Jeremy Glick, Mr. Newton, who's standing to my right, can you state your full name, please?
Matthew Newton. I have before me a plea form. Is that what we're doing today?
That's correct, Your Honor.
All right. Plea form indicates that the defendant would be pleading guilty to the charge of operating while intoxicated, second offense. That's the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the entirety of the court's understanding of the agreement.
Yes, Your Honor.
Please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Why does everybody state your name?
Matthew Newton.
Thank you. You can put your hand down. Why does everybody think they can wear shorts to court?
I shouldn't have.
What?
I said I shouldn't have. I don't know. I apologize.
You didn't tell him to do that, did you, Blake?
I did know he was
asked-
wearing shorts. I apologize. I knew he was coming from work. I'm sorry, Your Honor. I will eat that one, but it won't happen again.
How's that sore feel in the middle of your chest falling on that? All right, anyway, all right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor, punishable by up to a $1,000 fine plus cost, up to 1 year in jail. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I do.
And understanding that, and I should also advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in 1484 District Court. You understand that, sir?
I do.
All right. And understanding that, you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, did you?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
I do.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses?
Yes.
Offense? February 22nd, 2025, at the location of South Ann Arbor Road near Pleasant Bridge, City of Saline, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What you have and how much?
I had 3 or 4 Captain and Cokes over 4 hours or so.
Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
Failure to come to a complete stop at a stop sign.
You're not challenging the right of the police to stop you, are you?
Nope.
All right. Were you ultimately arrested?
Yes.
You were taken to a hospital for a blood draw?
No.
You were taken, was there an intoxicator done?
Yes, he was taken to the Saline Police Station where he.
And an intoxicator was done? What were the results of that?
At there is 0.100.
Do you have any reason to dispute those results?
No.
And had you previously been convicted on or about April 4th, 2003 in the 52nd District Court and or on or about May 29th, 2003 in the 48th District Court of operating while intoxicated?
Yes.
All right. I think we got everything there. All right. Is counsel aware of any other threats, inducements, any other inducements, pleas or promises? I'm sorry, let me do that again. Any other promises, threats, or other inducements that have caused this plea?
No, Your Honor.
None known to the people. I would just make a note for the record that the court did issue a recent order to comply, but no, nothing affecting the plea.
Yes, we issued an order to comply because he had been missing some testing.
Yes, and I've discussed that with Mr. Newton and he understands the importance of complying. And I will add that he has voluntarily notified probation every time that there has been a late test and tested negative shortly thereafter.
All right. All right. Sir, I do have to advise you, and I don't think there is any sentence agreement or any evaluations that have been done, but if there has been, I would advise you that if you do commit misconduct as defined under the Michigan court rule, that any evaluate, the court would not be bound by any evaluation or sentence agreement. You understand that, sir?
Yes.
And further, you would not be entitled, if you commit that misconduct, to withdraw your plea. You understand that?
Yes.
Now, counsel, have I complied with the court ruling? Would it be proper to accept this defendant's?
People are satisfied.
I'm satisfied, Your Honor.
Court will accept the defendant's plea. Count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
At 9 a.m. with Judge Freshour in Chelsea.
September 30th, 2025. What time?
9 a.m.
9 a.m. before Judge Freshour.
Your Honor.
Bond will continue. Thank you.
Thank you.
Court does call the case of the People versus Mark Cochin.
Good afternoon, Your Honor. Thank you, Vice Mayor, on behalf of the people.
And good afternoon, Your Honor. I'm Shannon Smith on behalf of Mark Cochin. Mr. Cochin, can you please state your name for the judge?
Yes, Mark Cochin.
All right. Here we go.
Your Honor, at this time, we're asking the court if we could please adjourn today's PCC. We're asking for a longer adjournment because this is a case involving voluminous discovery. I just received some videos. We need to make sure they work. We discussed August 14th, if this court would allow that. I also have discovery I need to tender to the prosecutor's office because there's a long custody battle and CPS case that goes into the criminal charges in this case. It's one of those.
Yeah.
And no objection to the August 14th date if that is acceptable.
Probable cause conference will be adjourned August 14th, 2025, 9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of People versus Willis Chair.
David I. Goldstein appearing on behalf of the defendant, Willis Terry.
Thank you. What are we doing?
Sitting for exam, Your Honor.
And Your Honor, as far as the date goes, would ask if you couldn't set it a little bit further out. The victim on this case is in the military. There was a co-defendant who's already gone to exam, and the victim was able to come on that day. The military was able to accommodate them. So I'm asking for a little bit more time so that we can arrange.
So there was already an exam held on the co-defendant.
I believe he ended up waiting, but the day of the exam, the victim was able to come. The military was able to accommodate him. So we're asking for, he said, a little bit outside to accommodate. Getting him there.
I'm glad she clarified because it was my understanding he had waived. So when she said he held, I was getting a little surprised.
And I just wanted to know because if it was held, this one would go. I tried to put this before that same judge, but it was
Understood.
not held. It's a waiver.
Judge, I don't have any objection. I mean, I had already looked at the 15th and that was going to be a good day for me, but if she's not available, that's fine.
What, how long, I mean, how long a period of time do you think you need to be able to arrange with the military to have them
Your
here?
Honor, if you could give us a month, we'll try to see if we can get it done.
Okay, what about August 12th? Would that work?
Your Honor, I've got two trials in front of Judge Conlon that are scheduled for Monday. One of them I think is going to be a plea, but the other one is probably going to go. I could do the 20th. I'm sorry, the 19th.
Would that work too? I don't have judges for that.
That is Judge Moore. Judge.
This,
I'm at noon on that. Oh, it's one of those days. Okay. Preliminary examination in this matter will be set on August 19th, 2025 at 9 a.m. before Judge Moore.
Judge Moore, Your Honor?
Yes, sir.
Thank you.
Bond will continue. Court does call the case People versus Antoine Pitts.
David I. Goldstein appearing on behalf of the defendant, Mr. Pitts. There's already a bench warrant for him, Your Honor.
Yeah, there is. He's not here.
No.
Yes, the community corrections bench warrant will continue.
Thank you.
Court does call the case People versus Julius Holst.
Yes. I'd reduce for Julius.
Your name, sir?
Julius.
Thank you. Sorry about that. Are we doing the plea form?
Yeah, no contest plea. I do have advice of rights signed from today.
The plea form I have indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing an officer. That is a one-year misdemeanor. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding.
That's correct. Well, thank you, APA 10.5, and I blame Mr. Gordon.
All right, may I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name.
I do these hosts.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
You understand what? No, you can put your hand down.
I'm
Raising
sorry.
it for me to call on you about.
I'm sorry.
You good?
Yes, sir.
Okay, all right. You also understand, do you understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure that you understand. And that is that it first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The other thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking a plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Civil liability, Your Honor.
So, sir, to that charge, how do you plead?
No contest. Oh, I'm guilty.
You're ready.
Oh, which one you're
No
gonna?
contest. I'm sorry.
No contest?
Yes, sir.
All right. You understand that by pleading no contest, you'll not have trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I'm sorry. No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
All right. Court has been handed and has reviewed Ypsilanti Police Department report for their case number 255809. Any objection to the court having reviewed that report?
Nothing, people.
All right.
No, Your Honor.
All right. Sir, I do have to advise you that if I do accept your plea, you understand that if you do commit misconduct as defined under the Michigan court rules prior to the time of your sentencing, that any sentence evaluation or recommendation the judge would not be bound by. You understand that, sir?
Yes, Your Honor.
And you also understand, sir, that you would also not be entitled to withdraw your plea if you commit that misconduct.
Yes, Your Honor.
All
I
right.
understand.
Is counsel aware of any other promises, threats, or inducements that resulted in this plea?
None from the people, Your Honor.
No, Your Honor.
All right. Have I complied with the court rule and would it be proper to accept this defendant's plea? Well, let me put it this way. Based upon a review of the report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Now, have I complied with the court rule and would it be proper to accept this defendant's plea?
Your Honor, I believe so, but if I could just confer with counsel for a quick second to make sure that we're both clear on one thing.
Sure.
Thank you, Your Honor. I think we're all
I
set.
believe that people are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be August 25th or August 13th, 2025. Time again? 10 a.m. before Judge Barr. Bond with its conditions will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court calls case people versus Joseph Tripp.
And Edward Lucas on behalf of Mr. Trim.
How you doing, Your Honor? Just Trim.
Thank you.
Your Honor, at this time, I'm asking for an,
Pardon?
if we're asking for an exam.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to 15. Preliminary examination in person will be July 15, 2025. 9 a.m. before Judge Moore. Bond will continue. Thank you. Thank you, sir. Court calls case people versus Aaron Brown. Oh, she's here. Both in Zoom. Okay, counsel, I can't hear a word you're saying.
Is it better now?
Oh, we could say something again.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Yep, we got you now. Okay.
Okay.
All right.
Your Honor, I was going to say that defense counsel brought to my attention that Mr. Fromm actually had a case in Wayne County that covers the same allegations. And so I'll be filing a no prosecution.
All right. Any objection to that?
No objection, Your Honor.
All right. This case is dismissed. Once it comes across, I'll sign off on it.
Thank you, Your Honor.
Thank you. Thank you, Mr. Fromm. Court calls case, People versus Richard Whittingham.
William Burkett on behalf of Mr. Whittingham. Mr. Whittingham, would you identify yourself, please?
Hey, Your Honor, I'm Mr. Whittingham.
Hey, what are we doing on this case?
Mr. Whittingham had advised me that he would like to have this case sent over to the district court. I've advised him that he has a statutory right to a preliminary exam and what would have to be done at a preliminary exam. He understands all those features, and with that, he's asking the court to send this case over to the district court.
To the district or circuit court?
Okay, circuit.
All right. Mr. Whittingham, do you understand that you're waiving your right to a preliminary examination?
I agree.
All right. And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
I agree.
And you understand you won't have that hearing and you'll proceed to circuit court for further resolution?
I agree.
I'll take that as a yes. Counsel?
The people also wait.
Preliminary examination having been made, defendant is bound over to the court on both counts. Mr. Burkett, you acknowledge receipt of the information, waive its formal reading, and your client stands mute?
That is correct.
All right, defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 26, 2025 at 1:30 with Judge Conkey.
August 26, 2025, 1:30, Judge Conkey.
Thank you.
Thank you. Bond will continue with its conditions. Court does call the case, People versus Anjane Yancey.
Hello, Your Honor. This is Anjane Yancey.
Hello.
I don't know if you can see me.
Yes, we can see you.
Okay.
Good afternoon, Your Honor. Gabriel Lacey for Miss Yancey.
I can't see you, Lacey. No, I'm kidding. All right. All right, what are we doing in this case?
Your Honor, I don't know if you would be willing to go into a quick breakout room with me and the prosecutor.
Okay, that really causes problems because then I got to move since you're on Zoom.
Oh, yeah. Okay. I hear what you're saying.
I mean, I can do it. If you think it's that important, I can do it.
I can put it on.
I'd have to pass it because I'd like to get one more case out of the way. But if you think it's necessary, I'll do it.
Oh, I don't mind you passing.
All right.
Thank you, Your Honor.
Pass this case. All right. Thank you. All right.
Good afternoon, Mr. Interpreter. Can you please unmute your device and raise your right hand to be sworn?
Oh.
Thank you, sir. Do you solemnly swear or affirm to interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Gujarati and from Gujarati into English in the manner now before the court to help you God?
I do.
Thank you, sir.
All right. Court does call the case of the People versus Vishal Kumar Patel.
That's the people.
Could you interpret that, please, Mr. Interpreter?
Yes, I will. વિશાલ કુમાર, હું જયેશ પટેલ બોલું છું. જજ સાહેબે હમણાં જ કીધું કે આ તમારો જે કેસ છે એ જનતા અને તમારો બેની વચ્ચેનો છે.
Good afternoon, Your Honor. Nicholas Mott. Oh, I'm sorry. I thought he was done. Are you done, Mr. Interpreter?
Yes.
Okay. Nicholas Monrez on behalf of Mr. Vishal Kumar Patel, present and standing to my right.
અને વિશાલ ભાઈ તમે તમારો જે વકીલ છે એમની જમણી બાજુ ઊભા છો.
May we approach, Your Honor?
You may.
Thank you.
Interpreter is still present. Go ahead, counsel.
Thank you, Your Honor. At this time, we're asking the court to set this matter for preliminary examination.
Could you say that, Mr. Interpreter, please?
Yeah. વિશાલભાઈ અત્યારે આ સમયે ખાલી પૂર્વ તૈયારી માટેના તૈયારી માટે તમારા એટર્ની એમ કહે છે પૂર્વ તૈયારી માટે તૈયારી કરવાનો સમય આપો.
Preliminary examination will be set July 22nd, 2025 at 9 a.m. before Judge Barr.
એટલે એ પૂર્વ તૈયારી કરવાની જે એક્ઝામ છે એ જુલાઈની 22મી તારીખે જજ બારની સાથે રાખેલી છે, નક્કી કરેલી છે.
Bond will continue. Thank you.
Thank you.
Thank you.
બાન્ડ ચાલુ રહેશે. અત્યારે જે તમારું બોન્ડ છે એ ચાલુ રહેશે.
Thank you.
Thank you, Mr. Interpreter.
Have a nice weekend, Your Honor.
All right, you do the same. sir.
Have a nice weekend.
Goes over that way. That goes in there. All right. That's the other one. All right, and is this my last?
You have the 3 o'clock in Zoom and then you've got the recall on Teams.
Okay, the 3 o'clock is, that's the comp. Let me do that one. Court does call the case of People versus Charles Hudson.
Good afternoon, Your Honor. Laura Willenbring on behalf of the people.
Good afternoon, Your Honor. Nicole Blank Becker on behalf of my client, Mr. Hudson. He is incarcerated. Is he there on Zoom as well, Your Honor?
You see him back? Huh?
Is he in custody?
She says he's in custody.
He is in custody.
Really?
His name was never on any of the lists.
His name never, okay.
So
All right, folks, hold on. Let me pass the matter. We'll get him up here or on Zoom. They can have him on Zoom. I just need him here when I do this.
okay.
All right. All right. Well, I'm gonna go off the record, take my conference, come back. By that time, hopefully we'll have him on Zoom. All right, counsel. Thank you.
Thank you.
Thank you.
Oh. Let me get this one out of the way. Court does call the case of the people state of Michigan versus Charles Hudson.
Laura Willenbring on behalf of the people.
Oh, you're muted, counsel.
Okay. Good afternoon, Your Honor, again. Nicole Blank Becker, sorry, Judge. It's been a long day. On behalf of my client, Mr. Charles Hudson, who is currently here now via Zoom. Thank you, Your Honor. We're ready to proceed.
All right. Sir, state your name, please.
Charles Hudson, sir.
All right. And counsel's requesting a forensic examination regarding competency. Is that correct?
Yes, Your Honor.
All right. And counsel, I apologize, but I just don't do them by stipulation.
No problem.
Okay. So I have signed the order and then we'll set a competency hearing date for October 2nd, 2025, 9 a.m. We are, so the council's aware, that's pretty much that period in time. We are getting some back quickly
Great.
for whatever the reason is. So if it does come back, we will notify the parties and set a hearing date in accordance with statute.
Perfect. Thank you, Your Honor.
All right. Thank you.
Have a good holiday, everyone.
All right, everybody do the same.
Thank you. Judge, do you have the ability to put me in a breakout room with my client?
With
or-
him? Yes, I have that ability. Would you like us to do that?
That would be
I
great.
usually don't, but I will.
Because I'm the last one.
No,
Oh, no, there's
because
another one.
because you're my favorite. That's why.
Of
No, I'm
course I am.
kidding. All right.
Thank you, Judge. I really appreciate
No,
it.
we'll make it happen.
Okay,
And
great.
we can
Thank
do that. All right.
Appreciate you.
There we go. Okay, court does call the case of People State of Michigan versus Yancey.
Those are the people.
Good afternoon again, Your Honor.
Good afternoon, Your Honor. Anthony.
All right. Okay, what we will do in this case, record true to the fact we had a bench conference in this matter. Discovery is complete, correct, Ms. Lacy?
Yes, that is correct.
And would the people be able to have their witnesses available on the 22nd? All right. So I will set preliminary examination in this matter in person for July 22nd, 2025, 12 noon before me.
Thank you, Your Honor.
Thank you.